Just let me know when you're ready. Ready?
Yes, sir.
Okay. So this is 20 CF 364, State of Wisconsin versus Lori Phillips, appearances.
State of Wisconsin by Andrew Burdick and ADA Jessica Skemp. Also at council table is investigator Fritz Lyon.
Good morning, Your Honor. Ms. Phillips appears in person with her attorney, Crosse, also at council table, paralegal Linda Gutsky.
All right. The state comply with the victim notification requirements.
Yes, Your Honor.
Last night, right after court yesterday, I sent you a draft copy of the jury instructions. We can talk about it at the scheduling conference, but I just wanted to send it to you a little bit early so you can take a look at it. Any other issues we need to talk about this morning, Mr. Zachar? Ms. Phillips we'll swear you in again this morning, just so you know. But
go ahead. I'll just put on the record that I'm told that there has been some gestures and arm flailing and eye rolling and comments from members of Mr. Phillips' family and supporter, and I would ask that the court just admonish them to not react as a police officer.
Okay. State, everybody I know this is emotional, and I know it's difficult, but this is a court of law. You have to show respect. You cannot say things. You cannot eye roll, cannot flail. I'm not sure if anybody's doing it, but if you do, please don't. If you were, please don't, I should say. Nothing was really noticeable to me, but my head's down most of the time anyway, to be honest. I take notes, so I didn't see anything. But I'm not paying attention. So, State, have anything else?
Your Honor, yesterday, replete through Ms. Phillips' testimony was evidence of other acts that the court deemed inadmissible. We did not object to them at the time, and specifically I'm referring to evidence of restriction or denials to use the cell phone. That was specifically prohibited by the court at the other acts motion hearing, and it's in your order. Mark, taking my cell phone, always taking my cell phone, he would usually do that. There were multiple comments, both by counsel and by Ms. Phillips, about the cell phone. And so at this point, I just want to ask the court to A, admonish them about that, and that there should be no further testimony, and B, that they are prohibited from arguing about restricting the cell phone use during closing.
Counsel.
Judge, that's not my recollection of the other acts order. As we recall, the court specifically allowed Ms. Phillips to talk about being isolated by Ms. Phillips by way of the incident with the internet at the home. And it was part and parcel, quite frankly, with the first physical attack of Ms. Phillips when her cell phone was taken after the fact, and that explains why Mr. Phillips was calling Adam Stevens from her cell phone and why that cell phone exchange applied. I don't intend to raise the issue again, and I didn't intend to follow any other acts order, if that's the state please.
Yeah, I think all the comments about the phone being taken were in the context of that night, mostly. I don't think they were replete with comments about maybe that one other incident. it was taken, but that was part of, I don't think, I mean, right now, I think the state's trying to say that, that there are references to other times he took it because this is something he would generally do, is take her phone. I don't even remember her saying that specifically, but I do remember her saying that in episodes that are part of the case. So I think references can be made about the phone being taken, for example, that night.
That night.
Yeah.
Absolutely, but number 3, it's in the order, number 3 that you signed, that he otherwise prevented her from maintaining phone access is inadmissible. So her saying he always would do that, and she did say that. And that should not be argued by Mr. Zacher, and I know he argued that in his opening.
Mr. Zacher?
Judge, I don't intend to argue it in closing, but
All right.
I would take the position that the state's waived any objection when they didn't make an objection at the time.
And I don't think it was a significant amount or a significant enough reference to actually violate the order. I did not see it as a violation of that order. There was not like, here, this situation where he took my phone, this situation he took my phone, this situation where he took my phone. That wasn't the type of testimony. It was, maybe it was too generalized because it was a response to those incidences, but if it's not argued in closing, that's fine, other than the particular incidences where the phone were taken. Does that satisfy?
Yes, thank you.
State? Anything else from the state?
No.
All right. And the jury is ready to come in. Let's bring the jury in. All right, everybody may be seated. Good morning, everybody. We'll get started right away. I think, Ms. Phillips, let's have you come on up. We'll have you re-sworn because it's a new day, and we'll continue with the direct examination.
You solemnly swear the testimony you give in this matter shall be the truth, the whole truth, and nothing but the truth.
All right. Morning, Lori.
Morning.
I think where we left off was talking about your access to the home security system after you had fled from Mark. So let me ask you about that. At any point, did you access the home security system through your telephone?
Yes.
Why did you do that, Lori?
I was looking to see if Mark either left the home or invited anybody over.
Okay, so let's talk about that a little bit. What would lead you to believe that Mark would leave the home?
What would lead me to believe that he would leave the home?
Yes.
He had stated he found some beer tokens to a home and bar, that he was going to go to that bar and pick up some ladies.
Okay. And Lori, did you have some sense that Mark might also try to follow you in the other vehicle?
Oh, yes.
Which cameras in particular did you check?
All of them.
Why were you checking all of them, Lori?
Because when I couldn't tell if he had left the house or not with the vehicle, or had somebody actually even come in, I thought, oh my gosh, maybe he's in the hot tub. So that's the reason for the hot tub as well.
Okay. And Lori, do you remember exactly where you were each time that you checked the cameras?
No.
Is it something that you were checking throughout the course of the evening just to see if Mark was up and about?
Yes.
Now, at any point, Lori, were you watching anything other than the live feeds from those cameras?
No.
And I'm going to ask you a question that you'll probably get on cross-examination. Were you checking these live feed of cameras to see whether or not Mark had been injured?
No.
Now, let's talk about where you went after using the restroom at Woodman's. Where was that, Lori?
So after leaving Woodman's, then I went back over by the Baymont, and there was like a vacant lot type thing across the street that was dark.
Okay, what was the plan once you got to that vacant lot?
To sleep there.
Okay. Were you able to sleep in the truck?
For a short time I did, I think.
Were you able to spend the entire night in that vacant lot?
No, it was too cold.
Okay. So, at some point you got cold. What did you decide to do then?
I believe I actually searched to see if there were any other hotels near me. And when I didn't come up with anything, then I decided that it was probably safe to go back home.
Okay. Well, what led you to believe that you were safe to go back home at that point, Lori?
Because if Mark, he would have been passed out by then.
Okay. That's something that you would have expected, that Mark was probably passed out and
Correct.
wouldn't have been up and aggressive.
Correct, yep.
Now, when you were going home, Lori, did you do anything particular with the cameras?
Oh, yes, I turned them off so that the alarm didn't wake Mark up.
Is that the sole reason that you turned the cameras off at that point?
Yes,
And what would lead you to believe that the alarm might wake Mark up?
because there's a beeping, I can't remember if it's a beeping or what it is, it's been a few years, but that it alerts your phone anytime there's movement.
Okay. Were you trying to conceal evidence of you returning home at that point, Lori?
No,
So when you're returning home, and I could get the envelope, please. This is Exhibit 526. Lori, do you recall exactly which way you took back to your home that evening?
Honestly, no, not until I heard somebody else state which way I drove home.
From the area of West Salem, coming from the, I guess it would be the east to the west?
Correct.
But you don't recall that specifically?
I honestly didn't remember that, no.
And Lori, did you see Mark at all when you were driving back home?
No.
Which driveway did you take when you returned back into the home?
So, the one to the left of the house.
Yeah, I'll give you the laser pointer. Why don't you point that out for us?
This one. Oh, sorry, this one.
So you've indicated the westbound driveway?
Correct.
And, or I guess the western side driveway. And Ms. Phillips, correct me if I'm wrong, but is that the driveway that you typically took regardless of which direction you were coming from?
Me, yes.
Now, let's describe the conditions when you were driving back. Was it light out at all?
No, it was pitch black.
Do you have any street lights or sources of artificial lighting right in that area that would have illuminated the area of the driveway?
No. Well, my truck lights, that's it.
So other than the headlights, nothing else?
Correct.
And as you were driving up that driveway, the western driveway, where was your attention focused when you were driving, Lori?
On the driveway in front of me.
In the Dodge Ram that you were driving, were you seated differently from how you would normally be seated in the Subaru relative to the driveway?
Well, yeah, I mean, it's a much bigger vehicle.
And Lori, at any point did you look over to the right or feel the need to look over to the right as you were driving up that west-facing driveway?
No.
Fair to assume that your attention would have been in front of you on the roadway?
Correct. On the driveway, correct.
Lori, I'm just going to ask you, did you see Mark out there when you returned to the house?
No.
How would you have reacted had you seen Mark?
I would have helped him.
Now, when you got back home, where did you park the vehicle?
Right here.
So, you've indicated the portico area between the back door to the house and the man cave. Is that correct?
Yep.
And am I correct in assuming that the front of the truck would be facing towards the east then in that view where you parked it?
Correct, towards the trees, right?
As opposed to when you left, the front of the truck would have been facing towards the west. Is that correct?
Correct.
When you got out of the truck, did you see Mark at all?
No.
What was your assumption of where Mark was at that point?
In bed sleeping.
Okay, so what did you do when you got back home?
When I got back home, I went inside, but I noticed right away the door was unlocked, which was very unusual, as well as the dining room light was on. But I did see my husband's shoes right at the doorway, so I knew he was sleeping.
Okay, so what was your impression then that the door was unlocked and the light was on?
I was like, wow, he must have been drunker than I thought and must have just passed out.
Okay, so what did you do once you got into the house?
I went inside. I went to the couch to sleep there, but A, it wasn't comfortable, and B, if Mark would have woke up to go use the restroom, he would have walked right past me, and that might have upset him, so I decided to go upstairs.
All right, and had you ever spent the night upstairs before?
No, I don't even know. Maybe been upstairs once or twice.
Okay, what was upstairs?
There's 2 bedrooms, but I slept in the small one right when you got upstairs.
Okay. Now, were you able to get any sleep up there?
A little bit.
And at any point during the evening, did you do anything else with the cameras?
Yeah, when I woke up at one point, and I remember thinking, where am I? I mean, because I was in an unusual spot. And then, like, everything was going through my mind of everything that happened that night. So I was like, oh my gosh, I need to turn the cameras back on so I don't get in trouble for turning them off to come home.
That's something that you felt that Mark would, that you would get in trouble for, so to speak?
Yes.
All right. So no dispute that at some point after returning home that you turned the cameras back on?
Correct. Sorry.
Yeah, it's a follow-up question. Overruled. Go ahead.
Okay. Now, Lori, about what time do you think that you got up that morning?
I want to say it was around 6:30.
Okay. Was it light out yet? Was it dark? What was the conditions that you recall?
I mean, it was lighter than when I got home, but it was still a little dark.
All right. So what was the plan when you got up? What did you intend to do?
Go downstairs and demand an apology from my husband.
At that point in time, did you feel that Mark would be violent or aggressive?
No, because he would have been more sober.
Okay. You figured that is this the type of state that you would go to Mark in when you would get apologies in the past?
Yes.
All right. So once you got up, describe what you did.
Once I got up, I used the restroom and then went to our bedroom.
And what did you find when you went into the bedroom?
Our bed was unmade, and there was like pillows everywhere.
Was Mark in there?
No.
Did that alarm you at that point, Lori?
Yeah, because I had no idea where he was.
So what was your thought of where you would look next?
I thought I would go see if he actually took the Subaru somewhere last night, and I just didn't catch it.
Okay. And when you were getting up in the morning, did you have your cell phone with you at that time, Lori?
No. Well, it was upstairs.
Okay. Upstairs where you had slept?
Correct. It was in my purse.
All right. And I'm going to ask that we go to a video on Ms. Witzke's computer here. And this will be Exhibit 507 from the video file, subfile video 1. Lori, do you see that exhibit up on the screen right now?
I do.
And is that you in the photograph to the left?
Yes.
Is that the position where the truck was parked after you returned back home?
Yes.
Lori, what are you doing in this video clip?
I went outside to go to the garage.
Okay, and I'm going to give you the laser pointer. I want you to point out where to the garage you were headed towards.
The door is right there.
Okay, so you're pointing at, looks like there's part of the side door visible on the garage, is that correct?
Right, it's brown.
At this point, Lori, did you have any reason to believe that Mark had been injured?
None, no.
All right, let's play the clip. All right. Does that Is that consistent with what you remember initially coming out of the house, that you were walking just towards the garage to see whether or not the Subaru was there?
Correct.
And Lori, did you appear to be upset or visibly shaken in that particular clip?
No.
All right, if we could get clip number 2 ready to go, please. All right, so Lori, did you make it all the way to the garage when you went out looking for Mark?
No.
Why not?
Because I saw my husband out of the corner of my eye.
How did you react to that?
I freaked out and I ran straight to him.
Okay. I'm going to play clip number 2 at full volume, please. Lori, what were we hearing in that clip?
Me
What were you doing?
yelling, crying,
And why were you crying?
because I found my husband dead.
Is that the exact moment that you saw that Mark was out there?
Yes.
Let's get clip number 3 up, please. Lori, what did you do when you saw Mark laying out in the snowbank?
I ran to him.
And what did you see about or notice about Mark when you ran to him?
That he wasn't breathing. He wasn't alive anymore.
What led you to believe that he wasn't alive?
His hands were like purple. I could tell. It was obvious.
And how did you react to seeing Mark out there dead?
I mean, I mean,
Give me a minute.
how did I react? I mean, I was in disbelief. I was in shock. I just ran. Then I ran inside the house to go get my phone to call 911.
You didn't have your phone with you at that point?
I did not have my phone. No.
I've got clip number 3 up here. Lori, do you recognize yourself in that clip?
Yes.
All right, if we could play clip number 3, please.
That one takes me right back to that day.
Lori, do you need a moment?
No.
What was happening in that clip?
I was running back inside to go get my phone to call 911.
And it sounds like you were screaming or crying during that clip.
Correct.
And it sounds like a stupid question, but I have to ask you, why were you screaming or crying?
Because I just found my husband.
Now, prior to these video clips that we just showed, Lori, did you have any idea that Mark had passed away?
No, none.
After running into the house, where did you go?
I ran upstairs to get my phone to call 911.
And we've heard the 911 call. I'm not going to play that again. But do you remember much about that call, Lori?
No.
Why not?
I was in shock. I just remember answering whatever they needed me to answer and trying to do whatever they needed me to do.
What did you hope that the 911 dispatcher would do?
Bring help.
Did you think at that point that there was any point that Mark could be revived based on your observations?
No.
So, do you recall Sergeant Valencia arriving at your house?
I wouldn't have known who he was, but yes, I remember a police officer getting there, yes.
And what was your condition or your state of mind when Sergeant Valencia arrived?
Again, I was in shock.
Do you feel like you had a clear head when you were talking to Sergeant Valencia?
No.
Do you remember much of what you said to Sergeant Valencia?
No.
How about Deputy Stoetinger, who took you inside?
I remember being inside with Mr. Leinfelder. I don't remember.
And let's talk about Mr. Leinfelder. Is that somebody that you had known of at the very least prior to February 22nd of 2019?
Yes.
In what capacity?
Just from Crosse. I've known Fritz for 30 plus years. Excuse me, Mr. Leinfelder.
Just from seeing him around?
Correct.
And do you remember much of your conversation with Mr. Leinfelder inside of the house?
I mean, I remember telling him, answering his questions. Do I remember everything I said? No.
At some point, did you go to the Holman Police Department to talk to Investigator Leinfelder?
I did.
And what was your impression of why you did that?
So that we could figure out what happened to Mark. So I could help him, give him any information I knew.
At that point, did you have any reason to believe that you were a suspect in Mark's death?
None. No, I thought Fritz was helping me.
And what were you trying to get out to Mr. Leinfelder when you were talking to him at the Holman Police Department?
What was I trying to get out?
Yeah, that was poorly phrased. What were you trying to communicate to him?
I just wanted him to know everything that happened and hoping that he could figure out what happened.
Lori, were you still upset during that time frame?
Yes.
Were you thinking very clearly at that point?
I'm sure not, no.
And were there details or facts that you left out of that interview with Mr. Leinfelder?
Clearly there were, because it had stated that in the video. I continuously said, I forgot this, I forgot this.
Was that because you were trying to mislead Investigator Leinfelder?
Absolutely not.
Now, do you remember Investigator Leinfelder asking you specifically about whether or not there was a history of domestic abuse during that interview?
Now I remember, yes, because I read the transcripts.
And at the time, do you recall indicating that there wasn't much of a history of domestic abuse?
No, I stated Mark's never punched me, is what I said.
Okay. Did you bring up the fact that Mark had choked you in the past?
That at that moment, no, I didn't want Mark to come off as a bad person.
Or any of the other incidents with Mark?
No.
And you jumped one question ahead of me, Lori, but why didn't you bring up the prior acts of domestic abuse at that time?
As I stated to Mr. Leinfelder immediately, he was a good man, and I didn't want to tarnish what his thought process would have been of my husband.
Is that why you said that Mark was such a good guy?
Yeah.
Now, do you recall having a discussion with Investigator Leinfelder about the fact that you and Mark had argued earlier in the evening?
Yes.
And Lori, at some point, did you try to show Investigator Leinfelder an area where you had a bruise?
Yeah, I remember telling him that I felt different in different areas, but I hadn't seen anything yet.
And did Investigator Leinfelder appear to take a closer look at your neck or chest area?
I remember him saying that he thought he saw something on my neck, yes.
Did anyone offer to photograph that or document the injury?
No.
Now, I do want to talk a little bit about the injuries here. And I'm going to go back to the Elmo, please. Do you recall Hannah Klinsky coming to stay with you after Mark passed away?
Yes, she came on Saturday.
And how do you recall, Lori, noticing that you had these bruises and injuries on you the following day?
It was after I took a shower and I got out of the shower.
And did Hannah have a reaction to the fact that you were bruised?
Yes, she's like, oh my God, we need to take pictures of this.
Okay. I'm going to show you what's been marked as Exhibit 520, previously received. Lori, what are we looking at there?
My leg.
And this is the The bruise that Hannah described as like a boot print or a footprint?
Correct.
Exhibit 522. Was that a photograph of?
That looks like another leg picture as well.
Exhibit 521. Can't quite tell if this is a shoulder or a leg, but is that a bruise?
It is.
Did you have bruising along your shoulders from where Mark had pushed you into the truck?
I mean, that picture, I'm not positive if that's a shoulder or a leg. I'm sorry, I don't remember.
Well, I'm asking, Lori, did you have bruises along your arm where Mark had?
Yeah, I'm sorry, yes.
I'll show you Exhibit 523. What is that a picture of?
My arm.
And what, if you recall, is that injury from?
Mark grabbing me and pulling me around the truck.
Did these bruises hurt Lori the next day?
Yes.
Exhibit 524. What are we looking at on this?
I see a bruise and something else, and then like that red mark.
Okay. And is that something that happened during when Mark had been physically abusive with you on February 22nd?
Yes.
This next one I'm not going to display. I'm just going to ask you to look at it. This is picture 525, the injury of the of your breast. What are we looking at here?
A bruise on my right, it looks like maybe my right breast.
Okay. Was that something that was sustained in the course of Mark physically abusing you on February 22nd as well?
It was.
Was that the bruise or the injury that you were talking about when you described to Mark that your boob hurt?
Correct.
At any point, did any investigator from the sheriff's department or otherwise ask you to come in and be photographed or otherwise document your injuries?
No.
Would you have done so had you been asked?
Yes.
Now, I want to talk to you about your comments during your interview with Investigator Leinfelder. Do you recall, Lori, whether or not, what your response was to Investigator Leinfelder when he asked whether or not you hit your husband with the truck?
I said I did not.
What's your impression, or did you believe at that time that you had hit Mark?
No.
To this day, are you even sure exactly what happened once Mark reached that driver's side of the truck?
I have no idea what happened to my husband.
Lori, do you know for certain that Mark was not in front of the truck when you hit the gas?
Yes, that's what I could see. I could see in front of the truck when I was driving away because my headlights were on.
We're getting to the end here, and I'm going to ask you the big questions, Lori. At any point when you were escaping from Mark on February 22nd of 2019, did you believe that you were creating a substantial risk of killing him or causing serious bodily injury?
Objection calls for legal.
For perception, Judge.
Well, it is a legal conclusion sustained. Go ahead.
Did you believe that Mark was at any risk when you were leaving?
No.
Did you believe that your act of leaving would be likely to kill or seriously injure Mark?
No.
Did you think that you even had a remote chance of injuring Mark when you hit the gas when he was on the driver's side of the truck?
No.
Was it ever your intent to injure Mark?
Never. No.
Lori, what was your sole purpose for trying to get away from Mark that night?
To get away from him so that I would be safe, to get to safety.
Despite everything that we've heard and everything that we've testified to in this trial, how do you feel about Mark today?
I love him. I miss him.
Thank you. I have nothing further.
Crosse?
Ms. Phillips, the last thing you had testified to, your sole purpose that night was to get to safety. Is that what you said?
Correct.
Okay. So for everyone hearing your testimony today, that's your sole purpose for that entire night? Is that what you mean in terms of escaping from Mr. Phillips?
When I left.
When you left, and then your actions thereafter?
Correct.
Judge, objection, vague.
Yeah, I agree. Go ahead. Be more specific.
So your sole purpose was to get to safety. You're talking about the driveway incident.
Correct.
Was that your sole purpose when you went to the subdivision?
To get to safety?
Yes.
I didn't know what I was going to do. I didn't know where I was going.
Was that your sole purpose when you went to check into a hotel?
Yes, so that I did not sleep at home, correct.
Was that your sole purpose, or sole consideration, or was that what and I guess, let me rephrase that. Was that a primary consideration after the hotel? Your safety?
Was my safety a primary consideration after the hotel?
After the hotel, when you're getting ready, I guess after the hotel, where you go next?
To Woodman's, you mean, or to the vacant lot?
To Woodman's.
To Woodman's. Well, I went there to use the restroom.
In the vacant lot?
The vacant lot, I went there to sleep because I couldn't get a hotel room.
And you didn't want to go home?
At that point, no, not yet, no.
Because you were concerned about your safety?
Correct.
Did you testify that there wasn't a remote chance that you hit Mr. Phillips with the vehicle?
Did I testify to when?
Just
Judge,
a few
I'm going to
moments
object.
ago.
That's mischaracterizing my question on direct.
If it wasn't what you asked, you can say no. Go ahead.
Did you indicate or testify in response to Mr. Zacker's question that you didn't think there was a remote chance that you hit Mr. Phillips that night?
Correct.
And you indicated that you don't recall speaking with Deputy Stoetinger the next day, February 23rd.
Was he the first police officer or the second?
I believe he would have been the second.
Honestly, I don't. I remember talking to Mr. Leinfelder.
So you remember Sergeant Valencia?
I remember a police officer coming. I wouldn't have known who he was.
So let me ask this a different way. You witnessed and paid attention to the last 4 days of proceedings. Is that correct?
Correct.
So even if you don't remember from this particular time, you, sitting in court, saw the different witnesses. Is that correct?
Yes.
And you saw Deputy Stoetinger testify.
Yes.
So now you know who that is. Is that correct?
I believe I remember which one he was, yes.
But you don't remember him at the time, at the scene on February 23rd?
I don't recall talking to him. I don't remember going inside with him. That was what I had stated.
Okay. So you don't remember, do you believe then that you would have said or indicated, I didn't hit him or anything, him being Mr. Phillips?
I didn't hit him. That's. Are you asking me if that's what I said?
I'm asking about your statement to Deputy Stoetinger. Is it my understanding? Are you saying that you just don't remember saying that at all?
No. Oh, you have confused me. So can you ask the question again, please?
I can. Deputy Stotinger, the person who testified, got up and he went up there and he swore to tell the truth, just like you are. And that Deputy Stotinger, you are saying that you do not remember speaking to him at any time on February 23rd, 2019.
I don't remember going inside with him.
Do you remember speaking with him in the driveway?
Well, I remember him stating that I had advised that I did not hit my husband. Yes, I do know what you're saying.
Okay, so you remember stating that? That it's not like I hit him or anything?
I said I did not hit him, correct.
Did Deputy Stotinger imply that you had hit him when you were speaking with him?
No, it was more along the lines of when I said, would tell the story, and that Mark ran around, and he's like, and I remember, like, and I'm like, well, I didn't hit him.
So the thought at least had crossed your mind that that could have happened?
When he kind of, like, questioned, like, gave me kind of a weird look, yes, that's why I was like, I didn't hit him.
So Deputy Stotinger gave you a weird look?
In my eyes, yes.
Okay.
Now, yes, I do recall what you're asking me.
Okay, so Deputy Stotinger...
I just don't remember going inside with him.
No, that's fine. So Deputy Stotinger gave you a weird look?
Like a questionable look, correct.
Okay, and that's what elicited that statement. It's not like I hit him or anything. Is that correct?
Correct.
Okay.
Can we not, like, step on each other's...
We can, and I'm sorry. So after Deputy Stotinger gave you that look, did you talk with Investigator Leinfelder after that?
It would have been after that, yes.
Okay. And then after that is when you went to the Home and Police Department, is that correct?
That is correct.
And at that time, you had, I guess, felt accused, felt like someone was suspicious of you? What were you feeling? I mean, describe this weird look to us.
No, not with Mr. Leinfelder, I didn't know.
Okay.
Not at all.
But you had at least considered that it was suggested that that's what was being thought by Deputy Stotinger.
I just wanted to clear if he did question anything, clear that.
And then you do remember going to the Home and Police Department?
I do.
Okay. And was your testimony a few moments ago that while at the Home and Police Department, it was, I guess, your intention to help Investigator Leinfelder, whoever, determine what had happened to Mr. Phillips?
Correct.
Because you didn't know?
Correct.
So you were going to provide as much information as you could?
Yes.
And you were going to make sure that you provided important details?
To my recollection, yes.
And that's why you, oops, go ahead.
I'm sorry. No, go ahead.
Are you finished?
Yes.
And that's why you were willing to make a written statement to Investigator Leinfelder?
Absolutely.
And then when you believe that you remembered something that you had left out in that written statement, you supplemented it, right?
I did.
And when we watched the video, that was, and Investigator Leinfelder was reading parts of that statement, that was all accurate, is that correct?
To my knowledge, it was all accurate, yes.
I'm asking the clerk.
Exhibit number 81.
Yeah, I'm sorry. I am handing what has been marked as Exhibit 89 to Ms. Phillips. Your Honor, the parties had previously stipulated use an agreed upon transcript for the purposes of Investigator Leinfelder's interview. Is there any objection to me using that throughout my cross?
I agree that it's authentic.
Go ahead, Ben.
Ms. Phillips, what can you tell me about the camera system? What was your understanding of the camera system as it existed between February 22nd and February 23rd? And I'm asking in terms of how it functioned, what it did.
I mean, it was a camera system that recorded movements.
Okay. So it recorded movements, and you indicated you could live view it. Is that accurate?
Correct.
Ms. Phillips, again, you've had the opportunity, or you've sat through every witness that we've had here
I have.
in trial, and you've seen every piece of evidence that's been presented. Is that correct?
Yes.
And you were paying attention?
Yes.
Okay. Would you agree, I guess, I'm asking specifically about the timeline aspect of this case, that there are a lot of moving parts in this case?
Yes.
We have the 2 hotels.
Mm-hmm.
We have 2 or 3 bars. We've got your house, right?
Correct.
We've got other locations, correct?
Correct.
You've heard all sorts of texts,
Yes.
internet searches,
Mm-hmm. Yes.
other things that I'm probably forgetting about, but I mean, you would agree that there's a lot there to that. Is that correct?
Yes.
Or would you agree?
I agree.
Okay. Up until this point, do you have any issue with the times of things that have been presented in terms of text messages
No.
or the coming and going from the bar as far as timestamps we've seen?
I don't believe so.
And the arming, disarming, or viewing of security cameras?
No.
Do you recall speaking with Investigator Leinfelder about the security cameras as they were armed or disarmed on February 22nd, 2019?
Do I recall talking to him? I don't know if I recall, but I mean, I can go back to the notes.
Okay. Can you please turn your attention on the exhibit that's been handed to you to line 114?
Okay.
I'm starting with Investigator Leinfelder, and so let me do some more checking. Is it your statement, I just hope the cameras were on? I mean, I don't know if they were or not. I have no idea. Is that an accurate reflection of that, or?
You said 114?
Yeah,
It's
I'm
not
confused.
one. Yeah.
What page?
So, Judge, I'm using the line number on the right-hand side.
Okay, explain it to the witness. I don't have it, so I don't know what you're referring to.
But
Attorney Zach.
where are you at? 1014.
Yes. I think I might have figured out the problem. Ms. Phillips, can you hold up that exhibit, please?
Hold it up.
Yes. So I'm looking at the lines on the left-hand side.
Mm-hmm.
1014. 1014.
Oh.
Sorry.
Hold on. Where Fritz says, and so let me do some more checking?
Yes.
Okay.
And then the 1015, Lori Phillips, I just hope the cameras were on. I mean, I don't know if they were or not. I have no idea.
Correct.
And then at 1018, do you say, I'm assuming they were if I had to turn the cameras off to come home?
Correct.
So you had armed the cameras at 11:08 p.m., is that correct?
If that's what the time was, yes. And obviously when I did all this, I wasn't thinking clearly, so.
So you weren't thinking clearly?
Correct.
So when you were asked that question, you just didn't remember?
No, I just assumed that if I had to turn them off, that they were on.
Okay.
That's what I'm saying.
So you don't recall turning them on at 11:08 the night before, or you didn't recall them when you spoke to Investigator Leinfelder?
Correct. When I talked to Investigator Leinfelder, I didn't remember that part. Correct.
Okay. And you didn't remember checking the live feeds?
No, I'm not saying that. I'm not saying that. To me, it made sense when I talked to him that if I had to disable the cameras to go home, that they were on. That's what I'm saying.
So I guess, is it your hope then when you made that statement that the cameras were on during the incident with the driveway? Is that?
I was hoping they were on, correct.
Okay.
Yes.
Because when you spoke with Investigator Leinfelder, you didn't remember that you yourself had armed them at 11:08.
That is correct.
Had you calmed down by that point? And by calm down, I'm referring to, I'll ask that in a different way. We saw you were emotional when the arrival on scene. We saw you were emotional at the house.
Correct.
And that was understandable because, as you testified, you just discovered your husband's.
Correct.
Did you, I guess, have an opportunity? What was your emotional state during the interview with Investigator Leinfelder?
I mean, obviously I was still shook up, but I was trying to give him what he needed so I could go back home and be with my family.
Okay. Is it safe to say that you were at least more calm when you met with Investigator Leinfelder?
At the home and police department, yes. Like I said, I wanted to give him as much information as I could so I could go.
And you had already spoken to friends and family at that point?
Yes, I had people at the home.
And your friend Kimmy is the one who drove you?
Yes, she did.
Touching up on the end of your testimony, your direct examination, sorry. We saw pictures of the bruises again, and you remember that?
Yes.
The picture of the one on your leg, didn't you indicate yesterday that that was from you slipping out of the truck or hitting that footrail or something?
I said that could be the possibility from that one, yes.
Okay, so you didn't specifically say that that was not Mr. Phillips?
It could have been from the step rail.
Ms. Phillips, I want to walk you through different things we've kind of heard about throughout your direct examination. Starting at Sloopy's. That was the first place that everyone had went to. Is that accurate?
Correct.
And you had went to Sloopy's with Hannah. Hannah and Adam Stevens were there? Hannah and Adam Stevens were at Sloopy's?
They met us there, correct.
Okay, and that was early?
That was early.
And is that when everyone had started drinking?
Yes.
And did that include yourself?
Yes.
But everything at Sloopy's was okay?
Everything at Sloopy's was great.
And you went to the dive bar at about what time?
I want to say the drawing was at like 7 maybe, so we would have gotten there probably right before that.
And at what point in the dive bar did things, I guess, start to escalate with Mr. Phillips?
I mean, I don't know time-wise, but it would have been when we met up with Scott Cundy.
Okay. So you don't remember the exact time?
No.
Do you recall when the first incident of physical violence was with Mr. Phillips? About when?
Time?
Yes.
No.
Okay.
When we left the bar.
Okay. The dive bar.
The first time we left the dive bar, yes.
Okay. So the first time you left the dive bar, that is the first incident of physical violence with Mr. Phillips.
Correct.
And not to make you just retestify from yesterday, but what was the first time he put hands on you that night? The one you're talking about right now at the dive bar.
When he brought me back to the dive bar.
So you're at the dive bar at this point, or you've left the dive bar?
The first time Mark put hands on me is when he brought me back to the dive bar.
Okay. And that was in the truck or outside the truck?
In the truck.
Okay. And it was parked? The truck was parked?
Yes.
And at this particular time, can you remind me this particular incident, what he had done?
That's when he jumped over on top of me and was strangling me and yelling at me and on top of me.
So you're in the passenger seat?
I'm in the passenger seat. He jumped over from the driver's side.
From the driver's seat?
Correct.
Okay. And I want to clarify kind of, when you said strangled, I can't do it as well as Mr. Zacher, so correct me, but I guess it was like a forearm hold or it was a choke hold, or I didn't understand that. Could you please describe it for me?
He was using his forearm.
So you use his right forearm or his left forearm? Don't know?
I have no idea.
Was Mr. Phillips right or left-handed?
He was right-handed.
Okay. So he uses his forearm, and that goes up against your neck area, is that?
Correct.
Okay. And then he, applies pressure?
Yes.
Okay. And you're being pushed into the door?
No, in between the seats. Like, he's actually pushing me towards his side, his seat. It was in between the seats. Not towards the door.
So, okay. So I think if I understand correctly, so he has actually gotten out of the driver's seat and is on top of you at this point?
Correct.
Okay. So he's on top of you, pushing backwards towards in between the seats, towards his side?
Correct.
Okay. And then after that, you exit the car or the truck, and then that's when you go back into the dive bar, or is that?
Correct.
Okay. So, Ms. Phillips, after the dive bar, I guess, and like I said, there's a lot of moving parts in this case. I'm trying to figure out, and again, not to just make you retestify. So at this point, how inebriated do you think Mr. Phillips is?
Okay, the first time when we came back to the dive bar, you mean?
I'm talking
When?
right after he gets out of the truck. That he just had this incident where he used his forearm, got on top of you, and applied pressure to your neck.
He didn't get out of the truck then. But how inebriated do I think he was?
Mm-hmm.
Clearly more so than I thought. But, I mean, I don't know how you want me to monitor that.
So you remember answering Mr. Zacher's questions? His
Yes.
Yes.
Your Honor, can we approach?
These are your questions.
We need to approach.
Okay. Go ahead.
So, Ms. Phillips, during your testimony yesterday, you made a lot of representations about how inebriated Mr. Phillips was, what you thought about it, what that meant to you, things like that. Do you recall that?
I recall saying that Mark's a different person when he's drunk, if that's what you're referring to.
You refer, he's a different person, and, there's different levels of inebriation. Do you remember that for him?
Yeah, I mean, there's like buzzed and then there's drunk, yes.
So, yeah, buzzed drunk is fun. Buzzed Mark
Yes.
is fun Mark.
Yes,
And drunk Mark is a problem.
correct,
And Mark who does shots is a problem.
100%.
And Mark, I guess at some point when you said is annihilated, that was a problem.
Absolutely.
And at some point at the dive bar, he gets, per your words, annihilated. Is that correct?
I would say that would be at the end after like even doing shots and continuing to drink, yes.
Okay. So you have an understanding, based on the scale that we've just talked about, how drunk Mr. Phillips is. At any, at time. I mean, indicators, the way he looks, the way he smells, the different way he starts talking to you. I mean, things like that, right?
That is correct.
So at this particular time, how inebriated do you think he is?
Well, okay, so I would say he was drunk, but I've seen him much drunker before at that point.
Okay.
Because sober Mark wouldn't have done that.
Sober Mark wouldn't have done that.
Correct.
And now he has put hands on you. Is that correct?
Correct.
And at this point, who's all at the bar?
Inside the bar?
Yes.
Hannah and Adam and Hannah's family.
Okay. And
others that obviously that I don't know.
And Ms. Klinsky had testified that there was about 150 people at the dive bar. Is that correct?
I think she may have over-exaggerated when I look at the videos.
So you're looking at the video of just the part where the family's sitting. You're talking about that.
That whole section, correct.
Okay. So there's for sure not 150 people there. We all saw that, right?
Correct.
But the dive bar, I mean, I guess we agreed for the sake of time not to show out all the video, but it's a bigger structure, or it was a bigger structure, correct?
Yeah, there was another side to it, correct.
So there's multiple drawings?
No, there was one drawing.
Okay. So throughout that building, I mean, was there more people throughout the building?
Than just what we saw in video, yes.
Okay.
I just don't believe that there was 150 people.
Okay. And when did Mr. Phillips start, I guess, yelling and screaming at you? Are we at that point yet, or is that later?
Well, that would have been before. No, I'm sorry. That would have been when he came back in, yes. Actually, the beginning when he was yelling and screaming would have been after talking to Scott Cundy.
Okay.
I apologize.
So after talking to Scott Cundy, that's when the yelling and screaming starts.
Yes.
Is Terry LaFleur in the picture yet at this point?
No, he hadn't gotten there yet, no.
Okay. So this is just Scott Cundy, and he's screaming at you. Mr. Phillips is.
Yes.
Okay. And from that point, for the rest of the evening that you spend with him, he is, I guess, it's not the last time he screamed at you, correct?
No.
And he continued to scream at you throughout the bar?
In different areas, yes.
And there's that one period where you talked about he sends you the apology text, things seem okay, and then, I mean, I guess other than that period, is he screaming at you consistently? Are you arguing consistently?
Yeah, that was the only time that he was actually calmed down that I could tell.
Okay.
Well, I mean, so after the text message for a short time.
Okay. And that was at about 8:52 p.m.
That's when I believe I got the text message, correct.
Okay. And you remember you didn't respond to that text message because you were mad?
I didn't respond. You're correct.
Okay.
I was disappointed. I was mad and disappointed, yes.
Okay. Can you please look at the exhibit of, I think, line 426?
Okay.
Does it say, I mean, can you read that for me?
The 426?
Yep. Or no, excuse me, 428.
I didn't respond because I was so pissed off.
And line 426, when it says, you indicated, he was always sorry, he had texted me immediately, I'm so sorry, that's the text you're referring to.
The text I was referring to is he said, "I'm so sorry, I love you."
Okay, the one at 8:52.
Whenever it was, yes, correct.
Okay. So, not disappointed, you told investigator Leinfelder because you're pissed.
I was very disappointed with my husband as well.
Okay. So after he sends the apology text and things are at the bar, I guess what happens next?
I told Adam and Hannah that I thought that he had calmed down and that if they wanted to go, they could go.
Okay, so you flagged off, I guess, called off Miss Klinsky and Mr. Stevens.
I did.
And the rest of the family?
I had nothing to do with the rest of the family.
Okay.
I don't know what they did.
Didn't we hear something, I guess, did you hear something about that, I guess, Bob Klinsky or Miss Klinsky's father or stepfather, he didn't try to talk to you at all?
He did, yes.
Okay. Did he try to intervene? I thought we heard something about that. Is that your memory?
Well, that is what it appears to be. I don't remember what Bob said to me. I saw him come over and give me a hug and then kind of look over at Mark like I saw, thinking he was maybe trying to intervene, but I honestly don't remember what Bob said to me that night.
Okay, so he actually didn't attempt to intervene.
Did you say did or did not?
Did not.
No, I think he did. I think
Okay.
he did.
But you felt safe.
When Bob was trying to intervene?
Yes.
Oh, after Mark sent me the text, but this is you're talking about two different periods right now.
Oh, okay.
So that's where it's a little confusing.
So Bob Klinsky, that is his name, right?
Bob is Hannah's dad, but he was over when Mark was doing all the flailing and
Okay.
that's when Bob came over.
So that's earlier.
That's earlier.
And that's
Correct.
when he's still screaming and everything else?
Yes.
Okay. And the period afterwards where you then let everybody know towards the end of the night, them being Hannah and Adam, that they can go to Winona, that's later.
Correct.
And then and Mr. Klinsky, Bob Klinsky, he went with them as well, correct?
No. He lives in La Crosse, so he went to Pagan with them.
So he stayed at the bar.
I don't know what he did. I honestly don't know. That's when I was over on the other side with my husband.
Okay.
I don't know what they did.
So at that point, it's just you and Mr. Phillips at the bar?
With whomever he was talking to.
Okay.
Her family could have still been there, but I don't know.
And-
We're going to take a 5-minute break, okay? Ladies and gentlemen, we're just going to take a 5-minute break, okay? All right. There was a earlier sidebar which I dismissed immediately, which was Attorney Scamp accused Mr. Zacher of nodding his head and gesturing towards the defendant. Is that correct?
Yes.
And I didn't even give Mr. Zacher an opportunity to respond. I didn't see it. I didn't. Mr. Zacher, were you doing that at all?
No, I was not, Judge. This is just the way that I sit.
Right. Since then, I've been watching Attorney Scamp staring at Mr. Zacher, trying to note other things. Have you seen more things since? Have you written down any indication that he's nodding or indicating anything?
I'm watching for that.
Right. So much so that it's distracting. I think Mr. Zacher is very conscious of it, and I'm very conscious of it. I have to pay attention to the trial. Act professional. Stop doing this. Whatever it is, stop doing this. Stop staring at him because he needs to do his job, and I don't know if you're nodding or not, but do not nod or anything of that sort. If I've never seen this level of response. I mean, I don't if you continue to do it, it distracts the trial, and we will be here for a long time because they'll keep on taking the jury out. So you have a choice. One, trust that you're both professionals and act like professionals. Or two, we're going to keep on stopping the trial.
I just would like the record to know that because you did dismiss my concerns, which were brought to me by people in the gallery through a message, and I started watching, I sidebarred after I saw it happening more than once.
What do you think he did? What exactly did you think he did?
And Mr. Burdick would ask a question, would look at Lori and like slightly shake his head yes, slightly shake his head no. Sometimes he wouldn't, but there were times that he did. And it would look to me clearly that he was coaching her.
Right.
And I did
okay,
have
let me ask Ms. Phillips. Ms. Phillips, did you see him shaking his head yes or no?
No, I was paying attention to the person that was talking to me.
Did that influence any of your questions?
Not at all.
All right. Ladies and gentlemen, I will clear the gallery if I need to. So you have a choice. One, do not react. Do not text in this courtroom. Do not text in this courtroom. Put your phones away. I do not, if I hear there's more texting or any other indication, I will take your phone. This is a courtroom. Demeanor is you stay calm. I'm frustrated with this because you're delaying the trial. I don't believe anything inappropriate was done. We're going to move on with the trial. Of course I'm not. That's why I asked the jury to be removed. I think the outburst by the district attorney's office was somewhat inappropriate because it was so loud in front of the jury. I'm not going to give an instruction because I don't think it was loud enough. But it has to calm down, and it has to calm down now. This is a very serious trial with high emotions, and it must calm down now. Do both parties understand that?
Yes, Your Honor.
Yes, Your Honor.
Understand. All right, let's bring the jury back in.
Your Honor, I'm sorry. Can I use the restroom? I will be quick.
Yeah, go right ahead. Need to take a break. We'll take another 5 minutes.
Thank you.
All right. Everybody may be seated. Continue, Mr. Burdick. Go ahead. Thank you.
Ms. Phillips, my memory is that we were left off at the dive bar. Is that your understanding?
Okay.
I'm going to ask this as open-ended. Is there, I mean, in terms of before we had taken a brief break there, is there anything that you remember, I guess, in terms of where we left off or the question you were answering or anything that we missed? I'm asking an open-ended question that I don't remember where we are, and I'm giving you an opportunity to fill in the blanks if I miss something.
Judge, I'm going to object as to the form and vagueness and just ask that the state focus on an individual topic across.
Yeah. Are you saying asking her if she missed anything that happened at the dive bar?
No, Your Honor. I'm asking if Ms. Phillips, during the course of her last testimony, if there's something that we missed in terms of that she had more to say. Just go on. Okay.
Specific. Yep. Go ahead.
Ms. Phillips, I briefly want to understand Mr. Phillips' I guess, jealousy. When you spoke with Investigator Leinfelder, can I direct your attention to line 414 on the exhibit that's been handed to you?
Okay.
When you had indicated, referring to Mr. Phillips, so he always explained it so that I could try to understand it. He said, if I ever feel like someone's trying to take you from me, is that referring to his jealousy?
Correct.
Is that referring to his possessiveness?
Well, he would say, if anyone's ever trying to take you from me or if you leave me. So I didn't get the second half of that in there, I see.
And at line 417, you continue, or I'm going to lose you. Are you still referring to Mr. Phillips?
That's what I was talking about.
And then when you say, he goes, I can't control what happens in my mind. He says, I can't help it. I can't help it. So when that happens, we just have to deal with it. And I'm just like, I just can't even believe that he makes these things up in his head. Is that still referring to Mr. Phillips?
Correct.
And at line 421, that he gets in his head and he can't let it go. Is that still referring to Mr. Phillips?
Yes.
Okay. Is that a fair description? I mean, is that accurate? Is that a fair description of his jealousy?
Yes.
And his possessiveness?
I mean, I don't really like the word possessive, but.
Okay.
I mean, that
Use
is.
instead. Oh, sorry. Go ahead.
He was just worried that if anybody was ever going to take me away, he'd say, or if I ever left him.
Oh,
Plain and simple, those two things.
okay. So he was afraid of losing you.
Yes.
And in fact, we heard a lot of testimony from different parties regarding that he was fearful of losing you. Is that right?
That we heard that he was.
I'll just
mischaracterizing the. Yeah.
I'll just re-ask. Strike that question from the record, please. So, when he's afraid of losing you, that's why he is jealous of other guys, right?
Correct.
And that's why Terry LaFleur, I guess, was a problem here.
Correct.
And you had nothing to do with Terry LaFleur, other than an acquaintance, right?
Never. Correct.
But in Mr. Phillips' mind, he made this, I guess, can I call it delusional connection? Is that correct?
I would agree with that, yes.
And this delusional connection is that, I mean, he saw just some random dude at the bar, right?
Well, Terry wasn't there. Terry wasn't there yet.
So, go ahead.
Scott said Terry was coming. So Mark assumed that either Scott called him and said, hey, Lori Phillips is here. He would have said Lori Gamoki. Come to the bar. That's Mark's interpretation in my mind. But in fact, I believe that they had plans all along for Terry to come and meet Scott Cundy for drinks that night at the dive bar. Had nothing to do with us.
Okay. So when Mr. Phillips started getting mad about that, I mean, Mr. LaFleur wasn't even there.
Correct.
And Mr. Phillips didn't even know Mr. LaFleur, did he? Or do you know that?
I don't think he did, no.
So the only connection between Terry LaFleur and his jealousy in that is what, the Chapter 2 days thing?
Can you reword that?
I can. That his connection to Terry LaFleur is that he thought Mr. LaFleur knew you from, I guess, bartending days.
Okay, so you're talking about Scott Cundy. So yes, Scott Cundy said that of course you would know him because he used to bartend at Ghost Chapter 2, correct?
Okay. And that Chapter 2 connection, that's what made Mr. Phillips mad?
No. No. So
Go ahead.
So when Scott said, of course you know Terry, and then I was like, whoa, 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 what does that mean? I've never been with him. He's like, no, he used to bartend at Chapter 2. My ex-in-laws owned a Ghost Chapter 2, so I bartended there as well. So that's how he thought I knew him.
So what I'm trying to understand is, I guess, let me ask you this. There were over 100 people at the bar.
I don't even believe that, no. I mean, there was people at the bar, but I don't believe there were 100.
About 50.
I would say 50 would be good.
So there's 50 people at the dive bar.
Throughout the entire bar, I would say yes.
Okay, and there are other men at the bar, is that accurate?
I'm sure yes.
And we saw the video, right?
Yes.
And we saw all sorts of other, I mean, there's the guy with the $14.99 something shirt. We saw other people at the bar.
Okay, yeah.
Is that right?
Yeah, we saw other people at the bar, yes.
What was the connection, as you understand it, between Terry LaFleur and Mr. Phillips? So what about Mr. LaFleur do you think made Mr. Phillips so mad?
It was the way Scott said it. He said, of course you know who he is. That is what triggered my husband.
Okay. So it's that, I guess that context clue.
Correct.
Okay. I want to direct your attention to line 433. Ms. Phillips, you stated to Investigator Leinfelder, he's always told me I would never, ever hurt you ever. Is that referring to Mr. Phillips?
Correct.
So, like, I couldn't even believe it. That's referring to the physical attack that you experienced at the dive bar, right?
Correct.
And I'm not even going to lie, I made a scene outside. I'm like, you know what? You put your hands on me, I'm done. I'm done with you. You just go live your life, go. And that's when he stormed off or took the truck and just peeled away. Is that referring to Mr. Phillips?
Correct.
Okay. I want to understand your emotion there. What is going through your head? I mean, at that moment.
When I'm talking to Fritz?
Nope. So the moment, I guess that question refers to a moment, right?
That I talked to Fritz. Mr. Leinfelder, excuse me.
Did you make a scene at the bar?
No, so outside, I raised my voice to try to attract attention, yes.
Okay, so that's when you raised your voice.
That is correct.
And that was because I think I heard that 2 people were in the parking lot.
I don't know how many people were in the parking lot, but there were people out there, yes. They were smoking.
You yourself saw somebody.
People were outside smoking, yes.
And you were hoping to get their attention.
That is correct.
And you were hoping to get their attention because you wanted their help, right?
Yes.
And when you told Investigator Leinfelder, I'm like, you know what, you put your hands on me, I'm done, I'm done with you, you just go live your life, go. Who are you referring to?
That's me talking to Mark, but I think that was in my head.
Okay.
That's what I was thinking.
So that's what you're
I
saying.
didn't say that to Mark. I apologize. I didn't mean to overtalk.
I'll rephrase that last part of the question, and I will also try not to interrupt you or anything like that. I guess I apologize if I did. Where did you leave off? That's going through your head? That statement, the one that I had read, that's the feeling that is going through your head at that moment?
Correct.
Okay. So did you actually yell that?
No.
Okay.
No.
So I guess what did you yell to the people you were trying to get help from?
I was like, you've done enough tonight, stop. That's what I raised my voice and said.
So you directed that at Mr. Phillips,
Yes,
but you said it loud enough to try to get somebody else's attention. Is that the idea?
correct.
Okay. What happens next?
To my conversation with Mr. Leinfelder, or when I go in the bar? That's
What
the
happens
end of the
next
night.
at the bar?
Judge, I guess I'm going to object and ask the state to clarify at what point we're actually at.
Yeah, Mr. Burdick, please be a little bit more specific about your questions so that the witness and we know what you're talking about. Go ahead, you can ask specific questions. You're on Crosse. Go ahead.
You're in the parking lot. You just tried to, the point at the parking lot where you just tried to get somebody's attention. What happens after that?
That is when Mark physically walked me across, well, first pushed me, because that's the part, when I was leaving. And Mark came out and busted me leaving, so then I parked the truck and got out, and that's when Mark assaulted me again, and then walked me around and put me into the truck.
Okay. And at some point, you were communicating or getting calls from Adam Stevens. Is that accurate?
No, I don't think when I was with Mark I did.
Okay.
And if I did, then I forgot that. After that, I did.
How about this? I'll focus on, can you please turn to 522? Line number 522.
Okay. Okay. That's a totally different time.
It is.
Yes.
And you told Investigator Leinfelder, I took the phone and I said, leave Stevens out of this, quit calling Stevens.
That is correct.
Who are you talking to?
Mark.
And you're talking to him in person or you're talking to him on the phone?
I'm talking to him on Adam Stevens' phone from when my husband was calling Mr. Stevens 3 or 4 times in a row.
Okay. And you're mad?
I didn't understand why he would bring somebody in from the outside. I just said, leave him out of this.
So were you embarrassed?
That was very embarrassing that he continued to call my friend.
So you're embarrassed because Mr. Phillips is calling your friend Adam Stevens?
To tell me to talk me into getting in the truck with him.
And you didn't want that information known?
I wanted him to leave Stevens alone, is what I wanted.
Okay.
He shouldn't have ever involved him.
And are you disappointed or are you mad or what's the emotion?
I was just like, leave him alone. Stop calling him. Like, quit bugging him. So my emotion, I guess I would be upset, I guess. And embarrassed.
Ms. Phillips, do you agree that you left the dive bar for the last time you had used at about 10:09 p.m.?
According to what I remember Mr. Leinfelder saying and seeing, I believe, video footage, yes.
Okay. And then you and Mr. Phillips, you had one more fight in the parking lot after you left or no?
When we left for the final time, that was the fight that we just discussed.
Okay. At the dive bar?
At the dive bar.
And then you go, I guess, took about a minute, 2 minutes? When did you get back in your car, the truck?
From when we left,
The dive bar?
I mean, a few minutes.
Okay.
It was 5 years ago. I mean, I don't really remember how long it was, but we were out there for a couple minutes for sure.
More than 5?
I don't think so.
Less than 5?
I would say so.
And then did you and Mr. Phillips go straight home from there?
Yes,
And he's driving?
correct.
And you were in the passenger seat?
That is correct.
And he's screaming at you at this point?
He was bringing up Terry LaFleur again, yes.
Is he screaming at you, or is he bringing him up, or is he speaking to you?
No, he was definitely yelling, correct.
And do you go straight home?
We did go straight home.
And I believe I heard, or do you agree with Deputy Sloan's assessment that it takes about a half an hour to get from the dive bar to your home?
I would agree with that.
So it's about, would you say, 10:42 to 10:45 when you and Mr. Phillips pull in the driveway?
Sure.
Do you agree with that?
Sure was affirmative, but yes.
When do you take off your ring and give it to Mr. Phillips?
On the ride home.
On the ride home.
Mhm.
So he's driving, and go ahead.
Correct, yes.
And do you put it in the cup holder? Do you hand it to him? Do you put it in the glove box? Where do you physically put that ring?
I handed it to him.
What did he do with it?
I said, I don't want this. And he put his hand out and he took, well, I can't remember if he said this at first, but he said, please, please don't give that back to me. And then maybe took it. I don't know if I just continued to hold it out there for him. I just remember he took it.
Was that sadness you saw from him, or anger, or what do you think his emotion was?
Objection, speculation.
I think we heard testimony on it yesterday.
If she can talk about her observations, go ahead.
Your observations.
When he said, please, please don't give that back to me, I mean, he wasn't screaming at me at that point. He was being genuine.
And did he stop screaming after that point? During the ride home?
No, I'm fairly positive that it continued. I mean, as far as I remember, it continued the whole ride home except for that short little point of giving him the ring back.
Do you know how long that short little point was?
I mean, it was just, I handed it to him and I said, like, here, I don't want this, or I'm done, or something like that. And he said, please, please don't give that back to me. And then ended up taking it because I guess I just continued to hold it out to him.
So you're holding it? I guess hold it out to him. What do you mean by that?
Holding my ring. I took my ring off and gave it to him.
And he never took it?
He did take it.
Okay.
Yes.
And then you get to the driveway. You pull up to the driveway at the residence.
Okay.
Is that correct?
Yeah, at some point, yes.
Okay. And he goes inside first?
He did go inside first.
Okay. How is his emotional demeanor? What are you observing at that time when he walks in that door?
I mean, he just took off. So, I mean, I didn't know what he was doing. I didn't know if he really had to go to the bathroom quickly but I mean, come to find out that he went straight to the safe to put my ring in there.
Okay. So he took off, so he's traveling at a faster than normal speed? Is that what you mean by that?
I mean, I don't remember. I just remember he took off because he's right there. The vehicle was parked right where he could just get right out, whereas I had to go around. And so he beat me in the house. That's all I can say.
Does he slam the door, throw the door open, anything like that?
I don't remember.
You don't remember?
I don't remember at that point.
And you indicated that he went to the safe.
He did go to the safe to put my ring in there, yes, and lock it in there.
Okay. And where's the safe?
In the bedroom.
The master bedroom.
Correct.
And you go inside to put some seltzers in and get your contacts, right?
Correct.
Okay. Is it safe to say the contacts were in your bathroom, or were they somewhere else?
Yeah, they were in my bathroom.
Okay. At what point did you make the decision that you're truly going to leave?
I knew when I was going home I was truly leaving. I'm sure he knew that as well.
So on the way home, you had already made up the decision, I'm gone.
Absolutely.
Okay. And you gave him the ring back.
I did.
And that was because, I guess, were you intending to end your marriage, or?
I was letting him know that his actions were significant enough for me to just give up that night.
Okay. Did you have the keys to the truck, or were they still in the truck?
We both have keys.
Okay, so you both have keys.
Mm-hmm. Correct.
Were yours on your person, or did you have to get those from inside?
No, they would have been in my purse because I always have my keys with me to be able to get in and out of the house.
Okay. So you have your keys, you had them in your purse on you?
Correct.
Okay. And you went inside to put the seltzers away?
He had already been inside. The door was already open.
So the door to the house is open,
Correct.
and you have the keys outside.
I have my keys. He has keys and I have keys.
So I guess, Ms. Phillips, at this point, safety is your sole priority. That's what you said when we had started. Is that accurate?
When leaving, yes. When I left that night, yes.
And this is the point in the night where you have made up the decision to leave and you are going to leave. Is that correct?
Well, I had made that decision driving home. Yes.
And you had already experienced a Mr. Phillips that you had never seen before.
Well, I mean, the worst part is yet to come. I mean, we still had another argument yet.
You're talking about in the driveway?
Correct.
Okay, that's the worst.
Well, that's where Mr. Phillips, as we're going to call him, it was the most upset, I would say.
So that is the worst is yet to come in terms of his emotional state? Is that what you meant by that?
Yeah, I mean, I may have misspoke. I mean, I'm saying that we were not done yet for the night, so it still got worse.
And it got worse after he went inside? And then,
Correct, when he came back out, correct.
So when you say the worst is yet to come, I mean, at that point, it was physically worse much earlier, right?
Physically worse much earlier. Mark was the most upset when I was leaving.
Okay, and that's the most upset you've ever seen him?
Ever.
Ever?
Ever.
And did that surprise you?
What do you mean by that?
Did him being the most upset you've ever seen him, was that surprising to you?
Objection relevance.
Sustain. If you can just keep things moving, go ahead.
Okay. So, Ms. Phillips, I want to direct your attention to line 594.
Okay.
Investigator Leinfelder, when he starts the driver's side door, can you review that section of the transcript and confirm that we are talking about the incident in the driveway?
Yeah, I can tell by my information above what we're talking about, yes. So yes, the driver's side door meant the driver's side door.
And at 597, you indicate, and he said, well, I'm going to get my stuff then. Is that referring to Mr. Phillips?
That is correct.
And I said, take your stuff that you want, take it. That's also referring to Mr. Phillips.
Correct.
You told Investigator Leinfelder that Mr. Phillips said that.
He wanted to get his stuff out of the truck, correct. If I was going to take the truck, he wanted all of his personal items out.
And then at line 615 and 616, I'm starting at 615. Can you direct yourself there?
I'm there.
Investigator Leinfelder, okay, so then you got in the driver's side, and that's when he came out and was going to hit the window again. Okay, and then he said, I'm going to get my stuff out.
Correct.
Okay. And you, at line 617, confirmed that?
Correct.
Because that's accurate.
Yeah.
You didn't indicate that Mr. Phillips is screaming at you?
At that point, when he got over there, he was saying some things. But when he came out, he came out with the fist and then realized that I was absolutely leaving then. And then something clicked and he's like, let me get my stuff out if you're taking, which it was my truck, not his, but he was the one who drove it.
So when you say that was the worst you've ever seen him, I'm trying, I guess, what indicators of that? What made you come to that conclusion?
Sure. So he was saying, so when he got over there and he was going through all of the stuff in the truck, he was like, just so you know, I'm changing the locks. He was saying so many things He was trying to hurt me by saying things. And then, that he was going to go to a bar and go pick up some chicks or whatever wording he used for that. I might not be using his exact words, but I'm telling you what he said.
Okay, so he was saying mean things.
He was saying mean things.
And he was degrading you.
Yes, and then the can koozie with the breasts on it and threw it at me and said, this is all you're good for.
And you took that to mean, a pair of breasts? That's all you're good for? Is that what you took that to mean?
Or sex or something.
Okay, but you took that to mean he was degrading you.
Yeah.
And he has said mean things to you, he has degraded you, he has said that he is going to change the locks. All of those things are what you're referring to as the worst you've ever seen.
Well, after the phone dropped and I looked at him, that's the most angry I've ever seen him.
So the phone dropped. You're talking about when you had the phone and you dropped it because you were going to put the cameras on.
Right, when he tried to take it out of my hands, correct.
And is that when you yelled at him, I hope the cameras are on, or when did you do that?
No, when he came out with his fist out.
Which is after what we're talking about now, the degrading comments, the going through his stuff, things like that.
That would be before. That'd be before.
I'm going to clarify my own question to make sure that I am understanding you. The comments are before the phone and the camera.
Me saying I hope that the cameras are on is when he came out with the fist like he was going to punch the truck window again, or me, or whatever he was going to do.
When he came out of the house, or when he came around the truck?
When he came out of the house.
So at that point, he had already suspected something about the cameras, or no?
Objections calls for speculation.
Yeah, sustained.
Okay. So something clicked in Mr. Phillips. That's when he became the worst you've ever seen him.
When he clicked, it was, wait a minute, if you're leaving, I want to get my stuff. That's when it went from coming out to punch whatever he was going to punch, whether it be the window or myself, and then realize I was absolutely leaving. I think it was a stall method on his part that said, wait a minute, I want all of my stuff out of the truck.
So it's while he's going through the stuff in the truck. That is the worst you've ever seen him.
The most angry I've ever seen him is when the phone fell onto the ground.
Okay. And that's when he goes around the truck.
That is correct.
Okay. And we've heard testimony now from yourself, from others, that you have been choked, right?
I have.
And you've been hit?
I've never been hit. He's
Never
never
been hit.
punched me.
But, but he's grabbed you enough to leave bruises, right?
Correct.
And he's forced your head under the seat of the truck that night?
It wasn't under the seat. It was between the seats.
Between the seats. He used physical force against you in the truck?
Correct.
And at some point we heard testimony that he had broken into your place?
Several times.
And we heard, I mean, horrible things that he said. I'm not comfortable even saying them, but I mean, the N-word and stuff like that. We heard all that, correct?
Yes.
But this, in that moment, is when he goes around that truck, when something clicks, that is the angriest you've ever seen him.
The look I saw in him, yes. He was very upset.
Okay. So we're talking about a period of time when he goes from the passenger seat to your driver's side window.
Correct.
How many seconds is that?
2 to 3. I don't know. It's just running around the truck.
So what is the look? I guess describe the look. Describe the worst you've ever seen him. Is he yelling? Is he fuming? Is he?
No. So when I had my phone, and then when he jumped to grab it and it fell, as soon as it fell, I was like, oh no. I look at him and he had this just evil look, and that's just when he just tore off, and I was like, oh my God.
So it was a look.
It was an absolute look, yes. Was he screaming then? No, not that I recall. I just remember him just immediately coming at me or coming for me.
But it was that look that he gave you was the true worst you've ever seen him.
That's the scariest I've ever seen my husband, correct.
When he runs around the truck, does he have his fist up? Is that when do you remember that, or what's he doing when he's running around the truck?
Does he have his fist up? I don't think so. I mean, he's running around it happened in a matter of seconds. I don't know.
I mean, does he have the same evil look on his face?
He was very upset, yes.
Okay. Do you remember, can you answer, how does he walk around the truck?
He didn't walk around the truck, he ran around the truck.
He ran around the truck. And Miss Phillips, that's when you took off?
After he cleared the front and he was by my door, yes.
Okay. And you indicated, I'm looking at line 621.
Okay.
Investigator Leinfelder, so then I was just like, F this, and I was out, I'm gone, right?
What line are you on?
621 to 623.
I don't have that. Oh, I see it. I'm sorry. I found it. I apologize. Can you ask your question again? I'm sorry.
I can. So you're describing to Investigator Leinfelder, so then I was just like, F this, and I was out, I'm gone. Right?
Correct. I left.
I'm sorry, did you finish your answer?
I said I left.
And you described that again, this is, he's at the door. Mr. Phillips is at your driver's door.
Correct.
Did he reach up to open the driver's side door?
Well, that's what he would have been going for, yes.
Okay.
I couldn't exactly see, Mark, with how dark it was outside, but I know that he had cleared the door or cleared the front and was coming at my door.
And correct me if I'm wrong, did you indicate previously or somewhere that I guess you couldn't get the locks working?
No. So when Mark started running over, I tried locking. I was like trying to lock the doors. I'm not familiar with the truck, so I continuously tried to lock, and I don't know if I ever got it locked or not.
Okay. Can you look at line 647?
Yes,
And then I was like, F this, and then I took off. We're still talking about that same moment.
correct, I did.
I'm asking to publish Exhibit 41.
So,
No, I don't. I'm just asking if I can publish it.
and it's the interior of the truck, is that correct?
So, Arlo, could you?
It's the interior of the truck, correct?
Yes.
All right, I think it's been published before, go ahead.
Ms. Phillips, I thought I heard, and correct me if I'm wrong, is this the stuff Mr. Phillips was going through?
Correct.
So that stuff, that wasn't there when you drove home, right?
No, that's where I sat.
Yeah,
when we
because that's
drove
where you
home.
sat.
Yes.
Now, I would describe that as a lot of stuff. Would you describe that as a lot of stuff?
It was all in the middle console, correct. It's a lot of junk is what it is.
So all that stuff is in the center console.
Maybe he could have gone through the glove compartment. I don't remember. I think it was all in the center console, though.
So the center console, maybe the glove compartment, is there anywhere else you saw him go through?
No.
So Mr. Phillips is in the center console area getting this stuff.
Correct.
And he's taking it out and he's putting it on the seat and you're watching him do this, right?
I think he was doing it like in clumps. I mean, I don't think he was taking things out individually.
And while he's doing it, this is when he's saying mean things to you?
Correct.
Okay. And about how far is he away from your person at this point?
As far away from my purse?
What's the distance?
Did you say?
What's the distance between you and Mr. Phillips at this moment when he's going through his stuff?
3 feet.
He's at the center console.
He's standing outside at this point going through his stuff.
And when you have testified previously that he pushed you between the seats, you're talking about those two seats.
That is correct.
That is the driver's seat and the passenger seat.
That is correct.
So he is in between those two seats at the center console getting that stuff. Correct.
He wasn't, yeah, that's where he was reaching into, yes.
How long do you think it took him to get that stuff out?
How long was the delay is what I'll call it. I would say, I don't know, a couple minutes. I don't know.
Couple minutes.
That's a guess.
And you said you'll call it the delay. Why do you want to call it the delay?
Because I believe he was trying to delay me from leaving.
And is that where he got the HD bar chips?
He would have found the HD bar chips within that stuff somewhere, yes.
And that's when he's trying to verbally hurt you by saying he's going to go with other women.
Correct.
So, Ms. Phillips, can you direct your attention to line 908?
Okay.
He told me when he was taking his stuff out that he was going to go to HD. That's the HD Tavern, right?
That is correct.
So I assumed, because he's like, you know what, I'm going to use these 2 bar chips that I have tonight. I'm like, you go ahead, Mark.
Correct.
Did you say that to Mr. Phillips?
I'm assuming I did if that's what I said in this.
You take off, and you go to the subdivision, right?
Correct.
Do you know where that subdivision is?
Yes.
Where?
Well, I mean, I could drive there. I mean, I know where it is. I don't know how to, it was down the road like 2 miles from what I understand.
What road is it on?
Well, it's off of, it would be, I don't know if it's M or W because it changes at some point. So M or W, it's off to the left.
Do you remember when
Going towards Holman, excuse me.
Do you remember when Sergeant Valencia testified?
Yes,
Do you remember him talking about the 3 roads that could have been on the left there?
yes,
I think it was McCurdy,
yes.
Fryer,
Okay.
and then do you remember one other one? I started with an R. I don't remember.
Yeah, I mean, I don't know what the roads are called. I have no idea. But it wasn't, it was literally 2 miles away.
You don't know
Okay.
what the roads are called.
No, I don't know what the side roads are called, no. McCurdy, I saw him point out. Then you said there was a Fryer or something. I'm not familiar with what they're called.
And that's the main road, right? The one that goes to your house?
No, that's County Road M or W. I think it starts with M and then goes to W. I'm not sure. It changes.
How many times do you think you've driven by that particular road while you were living at the residence?
What road?
The highway, the same highway that we saw Sergeant Valencia drive down in his initial squad video.
The County Road?
Is that,
The highway?
I'll re-ask you. Ms. Phillips, are you familiar with the house you lived in?
Of course.
And you're familiar with the roads next to the house you lived in?
I don't know the names of the roads. No, I'm familiar with the main road getting to my house.
What is the highway, roadway, describe it how you want, that goes in front of your house, the one that connects to what we've been calling the W driveway?
Judge, objection.
County Road W.
Good relevance.
Yeah, I'm not sure why this is relevant. I mean, she's talked about the roadway. We have plenty of testimony about that. Go ahead.
Okay.
Move on.
So, Ms. Phillips, is it safe to say that you have thought of, discovered, considered other details that were not provided to Investigator Leinfelder? Is that accurate?
Oh, absolutely.
And you got to that conclusion by reflecting,
Yes.
and you got to that conclusion by thinking with a clear mind?
Well, no, like for instance, one time he had asked me if I went in the house, and I told him no, I didn't think I went in the house that night. But then the next day when I opened my purse and saw my glasses and stuff, I was like, that's right, I did go in the house. I had forgotten. I did not remember going in the house at that point. So there's things like that.
Okay. But in all that time, you never thought about what road the subdivision was on?
Objection, relevance, argumentative.
Sustain.
And turn off the screen, please.
Based on what you saw Sergeant Valencia testify to, are you able to determine what road you were on?
Judge, objection, asked and answered.
She has testified to being 2 miles down in some subdivision. She
Okay.
doesn't know the roads. She has said that about 3 times now.
Okay.
And just to clarify, it's a newer subdevelopment, so I don't know the roads. I apologize.
Okay. So you're in the subdivision, you stop. Why do you stop?
Because I was waiting to see if my husband was chasing me.
Okay. And then you tried to look to see if he was there, chasing you.
Look to see if he was driving? Yes.
Okay. And while that happened, you told Investigator Leinfelder that you thought you saw a police officer. Is that correct?
I don't remember that. I said that there was maybe a vehicle. Yeah, you'll have to point me out on that.
Can I direct? Well, give me just a second. Can I direct your attention to line 198?
198?
198.
Okay.
And this car came up, and I'm like, oh my God, it's going to be a cop. It's going to be a cop, and I'm going to get in trouble here because I had been drinking. So then I just like waited, and this car just pulled right into their driveway, right into their garage. So some white SUV, now do you remember?
So yes, there was a vehicle. I said, I didn't say it was a cop. I said it could have been.
But you were afraid that it was a cop.
Well, I was hoping it wasn't because I didn't, particularly want to be, I was sitting in a subdevelopment with my light sign, like, out of place.
You're sitting in a subdivision.
Yes.
With your lights out of place. Your husband you're thinking he's going to come after you.
Correct.
And you're thinking he's going to come after you because you just saw him act in what is the worst you've ever seen.
He was the most upset. I think you're taking my information out of context. I said the look on his face was the most upset I've ever seen my husband.
At this point, safety is your sole priority. That's what you said when we started. Do you remember that?
When I left the house, that is correct.
And you're in the subdivision that is about 2 miles down the road.
Correct.
And it took you approximately how long to get to the subdivision? Do you remember?
Well, if it's 2 miles away, I'm assuming just a few minutes.
And you saw a vehicle that could have been a law enforcement officer. Is that correct?
I saw a vehicle pull into the subdivision, yes.
And you told investigator Leinfelder that you were, I guess, worried it would be a cop. Is that correct?
I said it could have been a cop, yes.
And you weren't thinking about, thank God I'm rescued? That isn't what's going through your head?
No, actually, I was thinking about, oh my gosh, am I going to get in trouble for drinking and driving?
Okay. So you're worried about getting an OWI at that point, or drinking and driving, as you called it.
Well, right. I shouldn't have been drinking or driving, correct?
Okay.
Together.
And I guess, are you still in fight or flight mode at this point, or?
I had already left, so I already had felt safer.
Okay, so you already felt safer.
After leaving, yes.
And at the time you're in the subdivision, you're now feeling safer.
I was not at home anymore with my husband, correct.
Okay. But you thought he was coming after you.
I didn't know if he was coming after me or if he was going to the bar or whatever he was doing.
Okay. And then when you found out it wasn't a law enforcement officer, it was just some person in their neighborhood, right?
That is correct.
You didn't flag that person down?
No.
You didn't try to call that person for help?
I wasn't being attacked or anything at that point.
Okay. And then at 10:57, do you agree that's when you sent the text, the "Have a nice life" from Bismarck that we've seen several times?
If that's what the time was stamped on.
And you sent that to Mr. Phillips?
Correct.
And Mr. Phillips, well, let me rephrase that. 10:57, we agreed from our timeline that you got into your house at about 10:42 to 10:45,
Okay.
right?
Yes.
Do you agree with that?
Okay. Sure. Yes.
If you don't agree with that, disagree with that, and I'll move on. Do you agree with that?
I believe your time period is
Okay.
close, yes, I'm sure.
And then there's a period of time where Mr. Phillips goes in the house, correct? Right?
Yes. When we first got back home, yes.
And then you testify that there is minutes that he is going through that center console trying to delay for time. Is that correct?
That is correct.
And then you leave the driveway and you go to the subdivision that is about 2 miles down the road, correct?
That is correct.
So 10:57, how long do you think, based on what we just walked through, that you've been in that subdivision?
You mean how long I was there altogether?
Between the time you got there and the time you sent that text at 10:57 to Mr. Phillips.
I don't, it was 5 years ago. I have no idea how long I was. I have no idea.
That's fine. So you send that text to Mr. Phillips. I thought I heard yesterday, I thought I heard you say yesterday that you sent that sarcastically. Did I hear that right? Is that wrong?
Judge,
No.
I object to mischaracterization.
I'm asking her to clarify.
She can clarify.
So I don't know, the ending part is what I was not sure. I don't remember if I was being facetious or if I was being genuine when it said good luck in Bismarck. I don't remember.
Okay. And you sent that text to Mr. Phillips, possibly facetiously, maybe 5 minutes after you had just had this incident?
The facetious part would have only been the last sentence.
I'm talking about the text itself.
Can you repeat the question, please?
You sent that text, that possibly facetious text, to Mr. Phillips within 5 minutes of leaving your driveway. Does that sound fair?
Potentially.
And you were trying to accomplish what by sending that text?
Letting him know I was not going with him.
And that's the same Mr. Phillips that is jealous.
That is jealous, you said?
Yes.
Yeah, he's jealous, correct?
And that's the same Mr. Phillips who, when I read you that quote about the description of him, can't let you go.
Well, he didn't want to lose me, if that's what you're saying.
Can't let you go, won't let you go. That's what puts him into this extra emotional, scary state, that and alcohol, correct?
Yes.
And you were afraid that that same man was chasing you or going to chase you.
Anytime we got into an argument, he used to chase me, yes, to try and make things better.
Okay. Were you trying to upset him? Were you trying to...
Why would I ever want to upset my husband?
I'm not answering the questions here.
Well, I'm telling you, I would never try and upset my husband if he's had been drinking.
Okay. And then that's about when you start texting Hannah, right?
I believe so, yes.
Okay. And then at some point after that, that's when you go to the hotel?
After I left the subdevelopment, yes, I had gone to the first hotel, correct.
I guess, which was the hotel that you, tried to book a room and it didn't work out?
That was the Baymont.
Okay. So the Baymont, and you were hoping to stay there for the night?
Correct, so that was the second hotel.
Because you weren't going home?
Correct.
Because home wasn't safe?
At the moment, that was correct.
At the moment, you were at the hotel?
At the moment that Mark would have still been awake.
I guess if you had been in the hotel, if you had gotten the room, would you have just stayed there?
Absolutely.
Okay, so that was the plan?
Yes.
Okay. And then when that failed, eventually Miss Klinsky and her family, she'd indicated that you could have gone to Winona, right?
Yes.
Okay. And you didn't take her up on that offer?
Absolutely not, no.
Why not?
Because it would have upset my husband.
How so?
He actually didn't allow me to go to Winona without him.
Do you have any, I'm asking from the perspective of what you believe and experienced. How would he have found you in Winona?
What?
How would he have known you were in Winona if you chose to go that way?
I don't think that's the point. If I went to Winona and he found out, he would be very upset.
You're talking about him finding out the next day?
Correct.
Okay. But he wouldn't have been upset finding out that you were in a hotel?
Well, that's way better than me going to Winona.
Even when he's acting delusional and he's making weird connections?
There's no way I could go to Winona. I did what I was supposed to do and go try and book a hotel.
Okay. What you were supposed to do?
Well, it was not to go to Winona. I did the right thing.
I'm asking supposed to do per whom?
For that, so that I wouldn't upset my husband.
So you're still worried about upsetting him at this point?
Of course.
Okay. And then, it was, I think, somewhere around midnight, you send him the physical abuse quote?
Okay. I know I did. I don't recall what time it was, but I know it's all been shown, so I'm going to take your word for it.
Okay. point of that quote was that you wanted him to self-reflect. Is that why you sent that?
That is correct.
And self-reflect when?
When he read it.
So when he read it, assuming it was received when you sent it, when he read it, that's when you wanted him to self-reflect.
Correct.
And that wouldn't have made him mad?
No. Oh, so Mark used to send me daily quotes. So, I mean, he would understand me sending him a quote. It's something we did daily.
So the inebriated Mr. Phillips, the annihilated Mr. Phillips, the bad Mr. Phillips, he would have understoed that at that time.
It wouldn't have, I don't believe it would have upset him. Otherwise, I wouldn't have sent it.
Okay. So at this point, you've ended their marriage. You've cut it off, right? You've given him the ring back?
I did.
And you told him you're leaving,
That
right?
He's leaving without me, and that, you mean to Bismarck?
And you just took the truck, his truck,
My truck.
your truck.
It's my truck.
Okay.
I bought it.
So are you referring to that you bought it or that you drove it?
I didn't drive. I bought the truck before Mark and I got married. It was in my name.
Okay, so it is your truck.
It is my truck, yes.
Okay. But he would drive it.
It's my truck that he drove, correct.
Okay. And he's in a incredibly heightened state. That's what we heard testimony about, right?
Which part are we talking about?
Okay, I'll move on.
Move on, please. Yep.
This crazy person, this version of Mr. Phillips, you thought he was going to self-reflect.
Yes, because we do quotes every day.
Okay. In that moment, in your answer, I'll move on. That's correct.
Yes.
Okay. So, Ms. Phillips, I want to just touch briefly on these cameras. So you pull up the camera at 11:08, right? That's when you arm it again. Is that correct?
That's when I'm what?
When you rearm the camera.
Okay. I mean, if that's what the reports say, sure. I mean, I don't know times from that night.
And it is your understanding that the camera, it's your understanding that the camera detects motion.
Correct.
And you wanted the camera on to make sure that no one was coming or going.
That is correct.
And that was specifically Mr. Phillips leaving or some other female from going?
From coming.
Coming.
Yes.
Okay. So if someone had come in the driveway, the camera would have been set off, right?
Yes. I mean, there's been times where it hasn't gone off, but yes.
So why did you need to live stream it?
To see if there was any activity that wasn't caught on the camera. I can give you an example that Mr. Phillips, Mark's father, had pulled in one time to come get the trailer. And it was caught at the bottom that somebody pulled in backwards, and it woke me up. So I left my room and went out and didn't see anything else, but they were hooking up the trailer and leaving, and none of that was caught on camera.
Because it wasn't on or because it didn't see it?
It caught them backing up into the, so originally I thought somebody missed M or something, so they backed up and were going to go out of our driveway to a spot that they may have missed pulling off.
Okay.
So I didn't think anything of it when I got up, and then, because I wasn't even really dressed, I saw two men outside hooking up a trailer, and none of that activity was on our cameras.
So there's that one instance where the motion didn't pick it up? Is that what you're...
That I'm aware of.
Okay, that you're aware of. And then you check those cameras again at midnight?
Okay.
Around? And 1:35, right?
Okay.
Okay. And you're at what point in the Woodman's parking lot, I guess, what's going through your head at this point?
I wasn't at the, well, I mean, so now I'm back at the Woodman's parking lot?
You're at the Woodman's parking lot, that is what I'm asking about.
Okay.
What is going through your head?
At that point that I wasn't going back home.
So at Woodman's, you still had made the determination that it was not safe?
Right. I was going to still try and sleep so that, until Mark could fall asleep.
At what point did you make the determination that it was safe from the Woodman's parking lot moving forward?
Okay, so I wasn't at the Woodman's parking lot. I was at the other parking lot. When I woke up and I was cold, I did search again for hotels that I must not have found anything. And after that is when I determined that Mark should probably be sleeping by now. I want to say it was like 2-something. So I figured even if he went out, he would have been home in bed, passed out by then.
Okay. Home in bed, not home in the man cave?
No, home in bed.
Okay.
He wouldn't sleep in the man cave if he had the whole house.
Okay. Because I thought, correct me if I'm wrong, that you had found him passed out in the man cave many times before. Is that right?
If we had an argument, he would sleep in the man cave. But that's because I would be in the master.
Okay. So you did have an argument tonight, but he would not be there. Is that your understanding?
In the man cave?
Yes.
There would be no reason for him to be in the man cave when he's got the whole house, because I wasn't there.
So when you came home, you didn't check the man cave?
No.
Okay.
There would be no reason to check the man cave.
Did you check the garage? Right when you got home that night?
No,
Why?
because I saw his shoes inside the house.
So I want to make sure that I understand, well, before I move on. So you pull in the driveway, correct?
Correct.
And that's the W driveway, right?
The first driveway, correct.
And the garage we saw is right there. That's right?
Yes,
And the side door is also right there on the side of that garage.
correct.
You didn't check that garage when you got up to the driveway.
No, Mark would have been, if he went out, he would have been home by then. So I had no reason to check the garage.
And the dining room light was on, right?
The dining room light was on, yes.
And is that the big side windows that we saw on the W driveway in those pictures?
Yes,
So those lights are on.
correct.
And the door's unlocked.
The door was unlocked, yes.
And Mr. Phillips didn't lock that door.
Right, which is unusual.
And it was unusual.
Absolutely.
And you didn't think, this is strange, I should go check the garage.
Judge, objection. This implies a legal duty that hasn't been established.
Checking garage. Checking the garage, I'm not sure what legal duty there is there, but I'll let him ask the question. She didn't check the garage, if that's the answer. Go ahead.
That is correct. I did not check the garage.
So I want to make sure I understand clearly as well. So if Mr. Phillips is awake, at this point, there is a safety concern, correct?
Right, but I don't know why he would have been awake after 2 a.m.
That wasn't my question.
I'm sorry, but I did say affirmatively correct, yes.
So if he wakes up, we're back to where we were in the driveway in terms of it's scary, you're unsafe, you're fearful for your safety.
I think he may have been happy to have me home. I don't know.
Okay. But you were concerned about that, which is why you did not want to wake him up.
If he was home sleeping, correct. I did not want to wake him up. If he was sleeping, correct. You are right.
But the reason you went home is because you believed he was asleep.
Well, I didn't have anywhere. I didn't have anywhere else to go
Okay.
because I wasn't going to Winona.
Okay. You didn't have anywhere else to go other than Winona that you were aware of.
Well, there weren't any hotels, and I mean I wasn't going to call somebody at 2 a.m. and like Kimmy or somebody and say, "Can I come over?"
And when you had looked up physical abuse, was it quit, quote, or quite?
I'm not sure if it was quit or quote, to tell you the truth.
Okay. So the search engine you used didn't populate resources for anything like that, shelters, nothing? You didn't see any of that?
No, not that I recall, no.
And I'm referring for resources for domestic violence victims.
Yeah, I don't recall anything like that.
So when you pull into that driveway, the W driveway,
Yes,
you slow down. I guess you're coming from the WM intersection past the M driveway into the W driveway. Is that right?
correct.
And you didn't pull right up the M driveway. Is that correct?
Oh, yeah, I don't ever do the M driveway.
Okay. But didn't you testify that that truck, when Mark uses that, he takes that truck and it's always up the M driveway, facing the W driveway, right at the door?
It's always if he's coming from West Salem, yes.
Oh.
He does that driveway. I don't like that driveway.
Okay. So parking his truck in the opposite way that he likes, that he prefers, that wouldn't have upset him?
Objection calls for speculation, relevance.
Overruled if he was upset by that or not.
No, I mean, that's ridiculous. I don't know why he would be upset of how I would park a vehicle.
Oh, well, it is ridiculous, but we've heard that he makes assumptions, right? And he has delusions. Is that also correct?
What does it have to, I don't understand.
Thing.
I don't understand, I'm sorry.
I'll rephrase the question. You had said that you wouldn't do anything to upset Mr. Phillips.
Correct.
And you're referring in many other things, you wouldn't do anything like going to a hotel or something that would make him mad. Or not a hotel, Winona.
Correct.
So things that wouldn't set off a normal person seem to have set off Mr. Phillips.
Not my driving.
Not the driving.
Not the driving. I mean, he knows which driveway I take.
But not little things like you not acting a certain way or doing a certain thing or behaving the way he wanted you to, that didn't set him off.
Objection asked and answered, argumentative.
Sustained.
Okay.
Both counts. Go ahead. If we can move on, counsel.
Mm-hmm. So, Ms. Phillips, when you pull into that driveway and the direction you took, and you take that right turn to get into the W driveway,
That
right?
is correct, yes.
Are you going fast? Are you going slow?
I'm going a normal speed going up a driveway.
Okay. So you're not concerned that he is maybe awake?
At that time, no.
But you saw the dining room light, right?
I don't even know if I paid attention to that when I first pulled up. I don't remember. I mean, I don't know. I don't remember driving up and noticing the dining room light on, but it's, again, 5 years ago. I don't know.
But you did tell me a few minutes ago that those are the big side windows we saw
Yeah.
of that house.
That is correct.
Okay, so you didn't notice that light on when you drove up?
I mean, I might have. I don't, to this day, I don't remember. I don't know.
So, Ms. Phillips, you're going into a situation where a potential abuser is located. Is that fair?
A sleeping abuser is what was in my mind, yes.
And safety is your sole priority. Is that fair?
Objection asked and answered, argumentative.
Yeah, let's move on, counsel.
Okay.
You can talk about going up the driveway, but go on to other issues other than what you keep on saying over and over again. Go ahead.
Okay. Were you in a state of heightened alert of any variety as you're going up the driveway?
So move on.
Okay. That's a picture of the driveway, request to publish.
Yeah, it's been published before. Go ahead. What exhibit is it?
I believe it's 20. Ms. Phillips, can you point? Do you have the laser pointer? Ms. Phillips, can you direct with the laser pointer the direction you would have taken and angle it towards the stopping position of your driveway?
I'm sorry, can you repeat that? I didn't catch it.
Can you take the laser pointer and direct us the direction you would have taken into where you parked the car?
So I went up and parked the car, like more so over here.
Can we indicate on the record where the laser pointer was?
The laser pointer seems to be going straight up the driveway up to about where the embankment ends the corner of the driveway and then wraps around towards the stopping position that is the driveway between the man cave and the house. Is that accurate, Ms. Phillips?
Yes.
So, Ms. Phillips, once you get inside and I guess the dining room light's on, it's unusual. What happens next?
I went and laid on the couch.
Okay. And at some point,
Well, I apologize. I turned the kitchen, or I locked the door and turned the light off.
no further questions.
Any redirect?
Briefly, Your Honor. Lori, were you aware of whether or not Mark had multiple pairs of the same tennis shoes?
Honestly, I didn't. I don't know if I did know that or not because they're identical. They were identical.
Okay. Did he have 2 pairs of the same shoes?
He did. Come to find out, yes.
Now, referring back to the text message that Mr. Burdick was asking you about, was the entire text about going to Bismarck without you, was that entire text intended to be facetious, Ms. Phillips?
Absolutely not.
What was your intent with the text with regard to everything but good luck in Bismarck?
I mean, to let him know that I wasn't going, but I don't believe I was being malicious.
Lori, is the reason that you fled from Mark because he was degrading or degrading you or for some other reason?
That I fled from Mark is to get to safety.
Because you were scared?
I was scared of him, yes.
Just to clarify an issue on rule of completeness here. I'm going to page 21, start at line 647. 647.
I'm sorry, Attorney Zacher, is that my copy or your copy?
That is my copy.
Okay,
It's
I just saw the
exhibit A.
highlight. I want to make sure I didn't
Yeah.
leave my, okay.
Lori, are you there?
Yes.
You remember when Mr. Burdick asked you to read, and then I was like, F this, and then I took off?
Yes.
All right. Going immediately to the next page on page 22, starting at line 648. Investigator Lionfelder clarifies immediately, quote, so he was right at your door, end quote, and your response was, mm-hmm. Is that correct?
Meaning affirmative, yes.
Is that to refer to the fact that when you took off, Mark was right at your door?
Correct.
Is it fair to say that you still cared about Mark, still loved Mark, even after everything that had happened?
Outside of the scope of Crosse.
Yeah, sustained.
Lori, at this point, is it fair to say that you don't, or you know exactly what happened with Mark on that evening?
I have no idea.
Nothing further.
Any recross?
No.
All right. I think you may step down.
Thank you.
You need to give me things there.
Oh, yeah.
Give me that. Do you have any other witnesses?
Judge, could we give 5 minutes maybe?
All right. Ladies and gentlemen, we'll take 5 minutes. My hope is that we'll be done at noon with this testimony. All right, everybody may be seated. So I have good news and pretty much just good news. Just so you know, the defense has rested at this point. The state has an opportunity for something called rebuttal, but what you call rebuttal witnesses, they've decided not to do that. So the case is now completed and submitted to the jury for final jury instructions and deliberations. Just so you know, I'm just going to repeat one part, is we don't choose the alternate until we're completely done with everything right beforehand. There's 2 random alternates who will be chosen. I can't tell you how, and I'll tell you at that point how that's done, but it's completely random, by the way. So during this time, I think lunch is coming up. We will not start. I'm hoping to start right back up at 1 o'clock. There's a number of things we have to do before we can be ready for that last little part. So thank you for your patience on all this, but we will be up at 1 o'clock. And again, I know it's tempting since all the evidence is in. Please do not talk about the case. Wait till all of the closing arguments are done and the final 12 people who will sit in the jury are deliberating. We'll see you in a bit then. An hour and a half. Everybody may be seated. In your seats are the jury instructions I'm about to read to you, so I'll go through those at this point in time, and then we'll do closings. Now, members of the jury, the court will now instruct you upon the principles of law, which you are to follow in considering the evidence in which and in reaching your verdict. It is your duty to follow all these instructions, regardless of any opinion you may have about the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply the law to the facts in the case, which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions. And from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issue of the fact solely on as you view the evidence. You, the jury, are the sole judges of the facts. The court is the judge of the law only. Statutory definition of the crime. Second-degree reckless homicide is defined in 940.06 of the Criminal Code of Wisconsin is committed by one who recklessly causes the death of another human being. State's burden of proof. Before you find the defendant guilty of second-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Elements of the crime that the state must prove. 1, the defendant caused the death of Mark A. Phillips. Cause means the defendant's acts was a substantial factor in producing the death. 2, the defendant caused the death by criminal reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that her conduct created the unreasonable and substantial risk of death or great bodily harm. Jury's decision. If you're satisfied beyond a reasonable doubt that the defendant caused the death of Mark A. Phillips by criminally reckless conduct, you should find the defendant guilty of second-degree reckless homicide. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Presumption of innocence. Defendants are not required to prove their innocence. The law presumes that every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt the defendant is guilty. State's burden of proof. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. Reasonable hypothesis. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. Meaning of reasonable doubt. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or to hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give the defendant the benefit of any reasonable doubt that remains after carefully considering all the evidence. An information is more than a written, formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witnesses. Second, the exhibits the court has received, whether or not exhibit goes to the jury room. Third, any fact to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or by an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. If you find that the offense charged was committed by the defendant, it is not necessary for the state to prove that the offense was committed on the precise date alleged in the information. If the evidence shows beyond a reasonable doubt the offense was committed on a date near the date alleged, that is sufficient. The state has introduced evidence of statements which it claimed were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things: whether the statement was actually made by the defendant, only so much as the statement so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial. Whether the statement or any part of it ought to be believed. You should consider the facts and the circumstances surrounding the making of each statement, along with all the other evidence in determining how much weight, if any, the statement deserves. Remarks of the attorneys are not evidence. If remarks suggest certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the omission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over objection of counsel, the court is not indicating any opinion about the evidence. You, jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question the court did not allow to be answered. Do not guess at what the witness's answer might have been if the question itself suggested that certain information might be true. Ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony be stricken. Disregard all stricken testimony. The weight of evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of other witnesses or even of several other witnesses. In weighing the evidence, you may take into account matters of your own common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristics. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters to the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and other facts and circumstances which the defendant during the testimony which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of any other witness. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourself the reliability of things people say to you. You should do the same thing here. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. During the trial, a witness was told to assume certain facts, then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Carefully consider the closing arguments of the attorneys. But their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence and the instructions given you by the court. So I'm going to stop right there. We'll finish the instructions after the closing arguments. With that, the state will begin with their closing argument.
Your Honor, while Attorney Skemp is queuing up the PowerPoint, I do have a request. Since the court had asked us to keep our closing arguments at or under 45 minutes, may I have my cell phone in the area?
Go right ahead.
Okay, and I will keep it on silent, and hopefully there will not be any issues.
No problem with you having a timer. Let's go. If people could you fill into the seats, please? If we prefer if you could find a seat. Move over if you would. That'd be helpful. Thank you, everybody. If there's any more seats. Can't have you standing in the back. I'm sorry. Go ahead.
May it please the court, ladies and gentlemen of the jury, congratulations. We have made it to the end of the presentation. You have heard the cases of both sides. The evidence is in, and now closing remarks, as the judge had indicated. This is an opportunity for me to tell you about my case, but most importantly to prove what I have to prove to you beyond a reasonable doubt. I have an opportunity to go through the evidence that's been admitted. The judge has instructed you about evidence. I'm going to tell you and argue to you what I think is persuasive or in terms of what you should find, what you should consider, and I'm going to use that to kind of bear my burden and talk about why the state believes and is arguing to you that we have met our burden beyond a reasonable doubt. And then because I have the burden of proof, I get what's called a rebuttal after Attorney Zacher and the defense's argument. And that will be the conclusion of this trial pending your deliberations and instructions. So judge had indicated that this is a reckless homicide case. I wanted to start off with the elements that I have to prove and how we kind of think we get there. The first one is cause. So I have to show to you that Ms. Phillips was a substantial cause in the death of Mr. Phillips. So what is the cause of death here?
the 2019 Dodge Ram that Ms. Phillips had driven on the night of February 22nd when she left her driveway that night. And how do we, so now that, in terms of knowing that that is a substantial factor given what we had seen, that is our theory on cause, that the death of Mr. Phillips was caused by that 2019 Dodge Ram. How do we know that? This is a clip from Dr. Reichert's autopsy report. It wasn't known at the time when the investigators got there, when they were on scene, when they started doing things, but this is a snippet of Dr. Reichert's testimony. And I'm using the laser pointer to highlight the third paragraph, and I won't get in, we saw the pictures, we saw the details, but significant injuries, the blunt force injuries of the torso, the blunt force injuries of the extremities, including the upper limbs, left deltoid, etc. You heard evidence about the subdermal hematoma, you heard about our brain bleed, you heard about the 3 to 9 multiple compound cracked ribs. You heard that they were on the left side. You heard Dr. Reichert talk about how he ruled out other causes. And in many ways, Dr. Reichert is getting to his determination and how he's looking at the evidence in the same way we kind of talked about at the very beginning of the case when we were circumstantial evidence, ruling out process of elimination, ruling out causes, getting to a determination of what the cause of death was by excluding all other things that couldn't be the cause of death. Dr. Reichert testified to you that it was a crushing injury on Mr. Phillips, a compression type injury that ultimately caused Mr. Phillips' death. That death could have been caused by a combination of the significant amount of blood in the chest cavity as it compressed Mr. Phillips' lungs and the brain bleed that I had just talked about. So, Dr. Reichert also testified in terms of the things that could cause Mr. Phillips' death, in that it was significant enough that we can start ruling off common household injuries, other things. This isn't, he's found in the snow, not hypothermia. The injuries are too severe. This is not a slip and fall. Mr. Phillips, from a standing position, could not have slipped on some ice and fallen in the position that you later saw him because the injuries are too severe. They're too significant. The blunt force trauma is too much. Mr. Phillips, in terms of that, and Dr. Reichert had testified that his injuries are consistent, again, with it being crushed by something, a very large, heavy object. Based on what we heard in the rest of the case, there is only one possible, and I will argue further, but only one possible culprit of that particular injuries, and we can rule out a lot of the other things that you might think. The other possibility that Dr. Reichert had testified to as far as what could cause a crushing injury like that, he did say that a fall from a significant height, if someone, in this case Mr. Phillips, were to have landed exclusively on his left side, that could have been similar. The amount of force generated by hitting the, in this case, pavement, could have caused the significant fracturing in the subdermal hematoma. So how do we know it's the truck? And how do we know it was the truck driven by Ms. Phillips? And how do we know that it was the truck driven by Ms. Phillips on February 22nd, 2019? Starting off here, the laser pointer, this is a silhouette of the truck. Where it was when Ms. Phillips brought it home and she testified, or she indicated to investigator Leinfelder that she hadn't moved the truck. It was there. That's how she parked it. All the pictures we saw early on in this case of the position of the truck in the driveway before it was put on the flatbed tow, that's where it was. But most importantly, we know she got there before it started snowing. Lisa Knutson, as part of her duties as deputy medical examiner, told you that she looked up things like ambient weather conditions and the weather conditions leading up to the morning of. It began snowing at about 2:15. It accumulated about 0.15 inches. She observed that it was about 31 degrees Fahrenheit when she arrived at the next day. In terms of the snow, and we see exactly that the outline of the truck, Ms. Phillips, and that's consistent with her statement as well, that when she disengaged the camera, she got home, it was about
the 2 range. We saw other evidence relating to the home Wi-Fi when it was accessed. So Ms. Phillips gets to the home later before it snows. And then, based on Deputy Examiner Knutson's report, that is a little bit after. Yep.
I'm sorry, I should have given the warning that there's a body being displayed.
This is the position of Mr. Phillips in the snowbank. I will hurry through this one because it is sensitive. That is the positioning of his body. We know that this is important because we can see the snow that's covering him on the legs, namely there. We can infer from that Mr. Phillips arrived in that location before it started snowing. Go ahead. This is a picture of the side of the house. We see the 2 large windows that Ms. Phillips had let us know is I guess the dining room is somewhere in there, but that was where the light had kind of come out of. But that's the 2 large windows we were talking about. That's the front of the house. Up there, that's the camera on what I've been referring to as the W driveway. I submit this picture to you because if you thought that maybe Mr. Phillips, Dr. Reichert said a significant fall, Attorney Burdick, you have to prove to me the cause here. The state bears that burden, and I do. That is an inhuman jump. There is an inhuman jump. If Mr. Phillips were to somehow be in that tree you see in the top there, or the top of the roof, I won't dwell on this point, but we know that is not, the structures that we saw, what could have caused a significant amount, significant fall, a significant trauma impact type of collision. We have the garage. You saw pictures of the garage. You saw how much snow was on it. You saw how much that snow wasn't disturbed. You saw the icicles on the side of the house, a picture of that. You saw that none of those were broken off. Again, the roof of the house, there's no snow imprints, there's no anything like that. Deep enough that wouldn't have been, if it had snowed 0.15 inches. The snow depth, the displacement of snow, there wasn't that much snow. This isn't a blizzard. You also see that in the area surrounding, to the top of this picture, the banks, things like that, there's not an indication that there was any disturbance there, that something came through there. Or anything like that. So that's one cause you can rule out. In terms of the time, though, what if somebody else hit Mr. Phillips? A truck. I can't just say that a truck could have done it and there's a truck. I have to rule out other possible causes in order to get us there so that you're so satisfied beyond a reasonable doubt. Could it have been somebody from the road? No. The positioning of that body, you saw how far into the driveway towards the garage it was in relation to the house. It is too far from that road that it's not like somebody sideswiped him. Someone was traveling down, perhaps as Sergeant Valencia had testified to, that intersection with W and M and the blind spots and things like that. It's not like somebody lost control of their vehicle that way. It's not like somebody lost control of their vehicle or was not paying attention. Mr. Phillips is too far up the driveway. We know that other people, some other vehicle, maybe he was standing in the driveway and someone else came into the driveway and hit him with a vehicle or crushed him, ran him over. We know that is not the case because the motion cameras, they're activated by Ms. Phillips at 11:08 p.m. And that is right after she left. And her testimony and what we heard on what she has submitted to you is that, in terms of her testimony, is that, she left that driveway, he was alive, she didn't know. That was the last time anyone had testified or knowledge we have that Mr. Phillips was alive. She leaves based on her testimony, we know, and the other evidence received. That's about 10:50, 10:55. We know that by the time she sends that text at 10:57 that she is already in the subdivision. That subdivision is already 2 miles down the road. We have a pretty good sense of the time between when she's there and when those cameras are rearmed at 11:08, a few minutes later. So at that point, the cameras are operating. Motion is being detected. If there's going to be some, somebody comes into the driveway, either driveway, and comes back, we know that the cameras are armed. Ms. Phillips indicated that she gets back to the house around 2, maybe a little bit before. There's evidence submitted. I'll go through the timeline here in a few. But there is evidence submitted regarding that. Now, this is where the other pieces of evidence, again, we're ruling out cause. The snow matters because we know that Ms. Phillips got there before it started snowing. And we know that so she turns off the cameras. That's when they're now disengaged. So the argument I just submitted to you about the motion cameras, that's no longer working as of when Ms. Phillips disengages them. I'll confirm the time as we go through the argument, but just before she gets home. We know, and again, because of the snow on Mr. Phillips, that he was there in the time I had previously argued because, again, the snow is on top of him, and we heard testimony about that. So at that point, we know that the positioning of his body is, he's in a spot where he is there before Ms. Phillips gets home and not after, because of the accumulation of snow. We also know that when Ms. Phillips got to the back door, the lights were on, the door was unlocked, so it's a you can rule out the possibility that maybe he went out after the fact. Maybe he had left, he left the house not with the lights on, not with the door locked, in that small window between when the cameras are turned off and when it starts snowing. If he were to come home significantly later, again, we have that window where we can rule out those other causes that, maybe he went out and got dropped off with his friends and one of his friends ran him over, his friends being the people at the bar. We can do that, or some other person comes up the M driveway that is just unknown because the snow versus the door being unlocked when Miss Phillips gets home. He didn't leave after the fact or come home after the fact. Oh, sorry, before you do that. That's cause. Ruling out other causes, that's where we're at as far as what could have caused Mr. Phillips' death. And it is, in fact, consistent with everything we've heard in terms of the testimony, and it is ruling out those other possibilities. So that's element 1. Now let's talk about element 2, the other elements. Ms. Phillips' conduct created a risk of death or great bodily harm to Mark Phillips. Ms. Phillips' conduct in this case is the driving of that truck. The risk of death or great bodily harm was unreasonable and substantial. Substantial, focusing on that, is unreasonable and substantial. It's the kind of thing that somebody would know, they were aware. Well, I guess I'll just finish this. Lori Phillips, the last element, was aware of her conduct, created the unreasonable and substantial risk of great bodily harm. That's the reckless conduct piece of this. Ms. Phillips has to cause the death of Mr. Phillips by criminally reckless conduct. Recklessness is a state of mind. It's different from an intentional state of mind, but it has to do with her subjective awareness. She doesn't have to know that she caused his death. She has to know that her reckless conduct created an unreasonable and substantial risk. We're talking about a vehicle. We're talking about a truck. We're talking about something that has significant weight and impact. It is common knowledge. It is common understanding that traffic accidents are serious, that a vehicle is not a toy, that driving is a privilege. We all, if you've driven in your life or are aware of that, you know that driving is a responsibility, and it's because of how significant the damage can be, the risk of, again, great bodily harm, death, that kind of thing. We're talking about a vehicle. The unreasonableness, well, I'll get to more on recklessness. And again, part of this is, I'm using this to highlight the common affairs and knowledge. This is a picture of a yellow light. If you drive and you know, in terms of what you can be aware of, we've all been in that situation where you're going somewhere,
The light is about ready to, it's green, and then it goes to yellow, and then it goes to red. And you see the yellow light. And in that 1, 2, 3 second window, you have to make a decision as a driver. You have to make a decision as to the speed you're traveling, whether you'll make that light, whether you won't make the light. You have to be aware of other people around you. You have to be aware of what other cars are doing. You have to be aware of if there's some pedestrian in the road. You make all of those determinations in that window, that tiny window. You assess that risk, and you assess, am I going to make it? What are the risks if I don't make it? Will the light turn red? Will I go in the intersection? Will I cause a collision? Will I hurt someone? That is all something that is common knowledge when we talk about being a driver or a vehicle, that is the result of those kinds of decisions, and you have to take them seriously, and you have to make sure that you are assessing that risk appropriately. And as I had indicated, you also have to make determinations, not just of the cars, not just of the time of the light. I'm not arguing that, I guess you do have to think if you'd get a ticket or not, if you miss the light. But, if there's somebody a pedestrian that you didn't see wants to cross the road, maybe they have the walk sign, maybe they don't. Those are all the things you are aware of when you are getting ready to start a vehicle. Recklessness, drinking and driving. Another situation where it is common understanding that the relationship of alcohol and driving is not a good one. That contributes to the recklessness. Awareness of the risk. I'm arguing to you in terms of that this is a vehicle, that this is the kind of injury or issue that could create substantial harm to somebody. The unreasonable piece we'll get to in a minute. But awareness. Here we have a picture of the truck. We have a picture of the back door. This is a picture of the truck afterwards. We're talking about the truck that was parked not in this direction, but towards the W driveway, which you saw many pictures of. You're aware of that tight space. You have to make a decision on how much distance we have here. You have to avoid the trash can. You have to avoid the snowbank. But you're aware of what you're dealing with in the same way that you are when you go through the yellow light. You have to understand the intersection you're dealing with, and Ms. Phillips did understand. This is her home. She testified about the snow. She knows how it's laid out. She lived there. We saw pictures of the driveway. Further awareness, the headlights in the truck are on. It's illuminating the area. You can see down the driveway. You can see where that snowbank is. You have a good idea of the estimation of the distance, how much space you have to play with. In the situation that Ms. Phillips, the way she had described things with Mr. Phillips in the driveway, the passenger door is open. I'm arguing that you can conclude or think that, that the interior lights are on if the door is open. I'm making that inference. There's the side view mirror. We've heard about talking about that. I'm pointing up there. But you have to know that side view mirror, that's part of the clearance of your vehicle. Your vehicle, it's a part of the vehicle that you're driving. That has to be taken into consideration. That's another factor when you're weighing the risk of, can I do something? Can I do something? Is it safe to do something? So now we're getting into the unreasonableness part of this. It is not enough for me to submit to you or argue to you just that Ms. Phillips created a substantial risk. It has to be unreasonable. Ms. Phillips is mad. Ms. Phillips tells us this is line 621 through 623. This is Investigator Leinfelder's interview with her statement, go ahead and get your stuff out. So he was like getting everything out. And I don't remember what happened. But then he got all pissed off again, like he was gonna come get me. So then I was just like, F this. And I was out. I'm gone. That's Ms. Phillips' frame of mind. That's how she described it when she met with Investigator Leinfelder.
She met with Investigator Leinfelder. When we talk about credibility of a witness, their representations, their memory, there's been a lot of pieces in this trial where people and witnesses have talked about this was 4.5 years ago. This was within 2 hours after police arrive, or whenever she gets to the home and police station. We're talking about a matter of hours. This is the time when it was most fresh in Ms. Phillips' mind. This is the time when she is remembering and processing the night before. She is emotional. She is grief-stricken. That is fair. But this is her statement. And again, we call that an excited utterance in terms of, when you're not thinking, when you're not processing, when you're just reporting, this is what I understand and this is what I'm saying. Those are her words. And then Ms. Phillips tells us a little bit more. These are lines 535 and 547. So Investigator Leinfelder, at some point he leaves the passenger side around the front of the vehicle. Ms. Phillips, And Ms. Phillips, he was running for me, yeah. I'm surprised he didn't just go through like he could. And then Investigator Leinfelder clarifies, so he gets around the front of the vehicle. He's coming. Ms. Phillips, yeah, to my door. Ms. Phillips, again, in case she made a mistake the first time, and then I was just like, F this, and then I took off. That's the second time she says that. That's how she's describing what had occurred. And here we have, she knows that Mr. Phillips is in front of the truck, or at her door. She knows he is in close proximity to where she is going to drive that vehicle. She has to make those same snap decisions that we talked about, or I argued in terms of the yellow light, the decisions every driver has to make. And she's doing it right then and there, and she's been drinking. So this is the layout of the property. Again, this is not with the snow. This is the aerial photo that we've talked a little bit about. We have the back door. We talked about the clearance of that back door. We talk about the space that we have to play with. We talk about where that truck is. And then there's the snow and the way it's shoveled. The trailer, which is not in this aerial photo, is here because the Phillips were moving. That's the situation where Miss Phillips takes off. And she does it. Now, in terms of judges, we've heard a lot of testimony about what her version of events is. Here, the corroborating evidence is that she was mad. She was upset. She was not upset because Mr. Phillips was going to hurt her. She was mad because of the way Mr. Phillips was treating her. She was mad because Mr. Phillips is jarring, I guess, for lack of a better, he's saying mean things to her. He's saying what he did. We heard the testimony on that, and we know she's mad because she takes the cozy, the one that he just insulted her with, and she throws it back at him. You heard a lot of testimony from Ms. Phillips and other witnesses, and we start talking about how do we get to knowledge? How do we get to what somebody understood? You cannot reach into the mind of another person and know for sure what they were thinking. None of us are mind readers. The cozy, her description, the I'm, yelling, I hope the cameras are on. But that Mr. Phillips was coming around. Now at this point, and again, we've heard a lot of evidence about what happened at the dive bar, what happened, previously, and that's a different, that's a similar but different piece to this. At this particular point, she testified that Mr. Phillips, that was the worst she's ever seen him. That was the most emotional she's ever seen him. In that brief window is when it all clicks, and he comes around the truck. But the reason she made that determination is because of the look he gave her. After everything we heard, after what we heard in the dive bar, it was just the look. The eyes, the presentation, just the evil look that he gave her in that 2 to 3 seconds that he came around that truck. That's what caused her to get the F out of there. That's what caused her to hit the gas. And she did that knowing he was there, knowing he was around that truck, knowing how much clearance she had to work with because it's her house. She takes off.
This is a picture of the M driveway. This is a picture of one of the cameras. The state bears the burden of every fact. Judge told you that, and it's true. I have to bear the burden of the elements. I have to make sure that that happens. I will tell you right now and argue to you, it is not enough. I cannot prove this case by just saying Miss Phillips' story was not consistent. I can't bear my burden like that. And I can't bear my burden by saying that if Miss Phillips didn't know or didn't have the awareness that she created the risk that she did, that I can, and finds out much later that Mr. Phillips is there, you know, if that's when she discovers the body, either when she comes home or in the morning or, you know, sometime after that fact, that is relevant only to things, you know, in terms of her credibility. It is relevant to the indicators of guilt and the indicia of guilt, the acknowledgement of guilt, because we're getting to what she knew and what she believed and what she understood. The element is not that she knows she killed him. It's that she knows she created the unreasonable and substantial risk. But I will argue, I am offering this though. This is a picture of the driveway. We're looking at what Miss Phillips indicators in terms of how she presented the version of events. This is the driveway. There's that porch there. We can see the snowbank here in the top right. We can see the clearance. Those are not her tracks. These are not her tracks. None of these are her tracks. This is after the scene. But in terms of the man cave, coming around, we can see how much space there is to work with during that event that she described. And we can, in terms of her coming back the other way around when she came back that night, we can see that Mr. Phillips is poking out of the snowbank, and she indicated that, you know, in terms of how she drove by him, that she didn't see him. And here's the picture here. This is Exhibit 20, I believe. If Miss Phillips had come into the right, gotten onto County Road W, and then goes up the driveway, this is light, granted, but that's Mr. Phillips' body right there. With the white sheet that the ME or Tri-State put on him, Mr. Phillips was wearing dark colors at the time. Mr. Phillips was at night. Previously, that affects visibility. But this is the straight-on shot. And you can see him even with the white on white, and that this, when Miss Phillips would have arrived in the driveway, that this would have been 0.15 inches less snow accumulated on the side of that bank. The ambient light here, she talked about how the dining room light was coming through in terms of her testimony, these big windows on the side. And she has headlights, and we saw her headlights, or not her headlights, we saw Sergeant Valencia headlights, how they would have projected. So Miss Phillips pulls into the driveway, and Miss Phillips avoids the sunglasses, the same sunglasses we saw that have the glare, that have the reflection, that even if it's dark would have refracted the light back at her, these sunglasses. And and we can see the distance between that and Mr. Phillips' body up in the right corner. We can see again how it cuts here, going up to that narrow area between the man cave and the door. The driveway, the angle of the snow, how it was set up. This is not only the clearance on the other side, this is the last one. Okay. I'm turning over to, now that I'm in terms of the cause and the scene, I'm turning over to some of the things we know about the timeline. And speaking of timelines, I'm just going to check how I'm doing on time. Sloopies.
This is later, Mark and Lori at the dive bar. This is that picture at 8:31 of them coming back. Go ahead. Mr. Phillips re-entering the dive bar. The text. The surveillance camera of them leaving. At 10:04, this is now where we're getting to the end of when they go back home. You saw this video, or in terms of this particular part, you can see Mr. Phillips standing here. You can see Miss Phillips standing here. You can see that she's saying something to him. I would argue that it looks like she's arguing with him. 10:07, this is the text she sent to Miss Klinsky, and that she's deleting this text. She testified to you, and you heard her version that she did that because she didn't want Mr. Phillips to know that she was sending that text. This is the 10:09 when they leave. Ms. Klinsky responds. This is 10:51. He just freaked again. He was at the passenger side of the truck and tried to come at me around the truck, but I took off. I don't even know what to do. He has lost it tonight. He promised me he would never touch me. He lied. That's 10:51. At that point, Ms. Phillips is in the subdivision. More text between her and Hannah. This is the one 10:53. He's out of control. I am done. He can go to Bismarck on his own. His issues big time. Ms. Phillips at 10:55 tells her version of the events regarding what at this point in the timeline seems to be relating to the truck incident. That is very similar factually, especially relating to the earring about what we had heard at the dive bar, which was several hours sooner. At 10:57, this is another one where we can see where Ms. Phillips, her mental state, the frame of mind she was in. I wish you the best, but the best will never be with me. You lost everything tonight because you let your mind get the best of you. I cannot believe you put your hands on me. Good luck in Bismarck. Ms. Phillips indicated that Mr. Phillips' jealousy got the best of him, that he became someone she had never seen before, that she was unsafe, that she needed to prioritize, that this is her safety, that she took out of the driveway because she had to make sure that she was safe. 10:57. This is right after this incident happened. This is when she's in the subdivision. This is when she's looking back to see if Mr. Phillips is chasing her. She said she sent that text. You heard her testimony, but she sent that text because she wanted Mr. Phillips to reflect. She wanted Mr. Phillips, the person who had just acted this way, the person who was delusional, the person who was had become this jealous monster, she wants him to reflect. She's mad. She sent this text facetiously. She sent this text right after the fact because she just left the driveway. Because she just left the driveway after this incident, and just like when she had indicated to Deputy Stoutinger, she had reason to believe that maybe she hit Mr. Phillips. Offered for knowledge. And her emotional state, it's not consistent in terms of the version where she was attacked. This is consistent with Miss Phillips leaving the subdivision, being mad, and now checking. Again, that Mr. Phillips is so jealous that, the second he realizes you're leaving, he's going to come get you, but you're sending him this text. Ms. Phillips then looks into the hotels. Go ahead. Ms. Phillips arms the cameras at 11:08, and then she begins checking them. And it's worth noting the times on these, but she's now checking for Mr. Phillips. At this point, she knows, you've heard testimony, that those motion detectors are operating, that she's armed them, and she is saying that she's looking for potential people coming and Mr. Phillips going. She's checking to see the scene that she just left. She's live streaming it. And she does it 3 different times that night while she's going through her version of events. This is the Baymont Inn. This picture right here. Ms. Phillips indicated that she had booked that room for the wrong night. And Ms. Phillips has indicated that, you know, she was going to stay at the hotel. That would have been it, and that's so that she could be safe. She could be safe for Mr. Phillips. Here's the Woodman's parking lot. Ms. Phillips indicates that she's sleeping in the truck, that Mark had sent a text to his friends to go out. That's the happy hour text. We heard evidence that text was, I think, the 21st, but my words aren't evidence, so whatever you would remember, heard, experienced. But at this point, Ms. Phillips is in the Woodman's parking lot. She's continuing to check the video. She's continuing to check the video because she knows. Go ahead. So. And she knows. Because at this point, Ms. Phillips has an opportunity to go to stay with the Klinskys, to go to Winona. She has an opportunity to go with her friend. She has an opportunity to have her friend's stepdad come to her. Ms. Phillips has an opportunity to be safe. The hotel didn't work, but Ms. Phillips has an opportunity to go somewhere. She has an opportunity to go in the truck, but she doesn't do that. She continues to check the cameras. At this point, motion sensors are still activated. She still has the ability to, you know, she's live streaming. She's looking for, in her words, comings and goings. This is the part where Ms. Phillips, I guess, can't have it both ways in terms of her version of events. It's either she's scared, this is the worst experience she's ever had, this doesn't make any sense, I'm so terrified that I am unsafe and I need to focus on my safety, or is it that I needed to get home for a reason, or is it that I wasn't concerned for my safety? Because at this point, this is about the time she goes back. She turns off the cameras. She says that that's not to disturb Mr. Phillips. She indicates that, I guess she didn't indicate this, but I'm arguing she's going back to the situation, you know, not the situation, but she's going back to a house alone after turning down potential law enforcement help or thinking that it was a cop in the subdivision. She wasn't looking for help. The neighbor that pulled into the subdivision, she's not looking for help. Any of the time period that happened after that, not going to Onalaska, not taking an opportunity to go with the Klinskys where she would have had people to watch out for her, look over the place, call law enforcement on her behalf if necessary. She's chosen, or is indicating that she's going to go back to a residence alone with Mr. Phillips, the same violent Mr. Phillips that we heard about, the same, you know, terrifying Mr. Phillips, the possessive Mr. Phillips, the drunk Mr. Phillips. That's where she's going to go back. She gets back at around 2 a.m. She drives right past where Mr. Phillips' location is. She arms the camera, she goes to bed. You heard her version of events in terms of what she's doing there. And then she gets up, rearms the camera system before law enforcement arrive when a little after she calls 911 at 6:29:37.
Ladies and gentlemen of the jury, Ms. Phillips' actions show an acknowledgement and an understanding that she had a real good idea what happened in that driveway. Her behavior, what she did, how she did it, again, acknowledging what had happened, the checking the cameras, the making sure, the nuances in how the system is or isn't armed. The fact that she didn't go to Winona, and we'll hear argument, but she has her version of events. Did you switch the slides? No, that's fine. But in terms of that, how she comes back, all of that shows that Ms. Phillips knows. She has the acknowledgement of what had happened in that driveway. She knows that Mr. Phillips is in front of her. She knows that she took the F off. She knows that she did so because they were having an argument. This was, despite the other evidence, the non-physical part of the argument, and that based on the look, that is, with all of the understanding of how that driveway was set up and everything else, that's when Ms. Phillips takes off with Mr. Phillips in close proximity to her. She goes over him with her truck. She causes his death. That is unreasonable, and it is substantial. It is unreasonable because it's not based on her need to flee, as she indicated. It is based on her anger. It is based on her being in the heat of the moment. It is based, and perhaps very probably, based on Mr. Phillips and the way he acted that night, that he mistreated her in some capacity is going to be is not in dispute. That leading up to that moment, again, she's acting in the heat of the moment out of anger, not out of fear, not out of safety being the number one priority. And the reason you know that is because her actions after the fact are so inconsistent with that narrative. I just wanted to touch on this. This is from the autopsy in terms of discussing other things. Did Mark punch the window at the dive bar? It is worth noting that as hard as he had hit the window at the dive bar, that Mr. Phillips did not have damage to his hands. This is the truck. We've heard a lot of evidence. There is no problems in terms of, there isn't denting. The truck's in good situation. The truck did not have damage on either side. Mr. Phillips pushes Ms. Phillips up against that truck, does so with significant force, but there's no indication of the damage of that. Is that the done? Okay. So, ladies and gentlemen of the jury, we're about at the time where I'm at the end of my closing argument, I guess. We have ruled out cause. We've ruled out that there is only one cause, beyond a reasonable doubt, that truck is what was what crushed Mr. Phillips, causing his death, that Ms. Phillips drove that truck, that she knew, even though she was emotional, even though she was upset, even though she was mad, what she was doing. She assessed the risk. She understood the situation as far as what was going on and what could have happened. She did it anyway. Maybe she knew she killed him right then and there. Maybe she just thought she hit him, but she knew. She knew right then and there. And everything that happens after that is a narrative that is inconsistent with the evidence that is presented. Thank you.
Thank you. Mr. Zacher?
Thank you.
Wait, hold on, let me ask you, does the jury need a break, or can we just move on? Okay, looks like everybody's fine with moving on. Go ahead.
There was never going to be a good outcome on February 22nd. There were only two possible outcomes, and they were both bad. It was a lose-lose game that Lori Phillips was forced to play. I told you at the very beginning of this case that this is the story of an ordinary woman in an impossible situation. A case where somebody was forced to react, and she reacted the best that she could, in the few seconds that she had. Lori Phillips isn't perfect, but Lori Phillips isn't a murderer. It's often been said in the legal profession that accidents happen, but crimes are committed. This is not what we call a strict liability offense. The mere fact that somebody's dead is not a crime in and of itself. The difference here is on what the mindset was leading to the fatal injuries. And as Mr. Burdick noted, the state has several elements they have to prove. They have to prove actual physical cause. They have to prove that Ms. Phillips's conduct, not Mark Phillips's, but Ms. Phillips's conduct, created a substantial and unreasonable risk of his death or great bodily harm. They've got to prove the why. Was this so unreasonable under the circumstances that it constituted criminally reckless conduct? And finally, they have to prove knowledge. At the time that she knew, not should have known, but knew that she, Lori Phillips, was creating a substantial and unreasonable risk of killing her husband. Listening to the state's theory, I had one question during Mr. Burdick's closing. What is the state actually saying happened? We have this version of events of Mr. Phillips is dead, and Ms. Phillips must have done it, and then in the middle there's kind of an ellipsis of ... fill in the blanks. She must be in the wrong, ladies and gentlemen, because we don't like the fact that Mark Phillips is dead. State can't tell us that, how this accident supposedly would have happened. The state can't come up here and rule out Ms. Phillips's versions of events. The state can't come up here and tell you that she was so unreasonable under the circumstances because of this rage and not the fear that she expressed repeatedly in her contemporaneous text messages to Hannah, to Adam, to her statements to Officer Leinfelder after the fact, to her statements and her testimony at trial here, ladies and gentlemen. The state can't tell you any of this because they don't know. It's the state's job to know this. It's the state's job to fill in these blanks. And effectively what they're relying on is this assumption that she must be in the wrong without feeling the need to prove exactly why that is the case. I found it offensive, ladies and gentlemen. The state came in here and said, this is how a domestic violence victim should feel. This is how she should react. Ladies and gentlemen, the state has no business telling Lori Phillips how she should react. You're not going to know how that's going to go until you're in that situation yourself. The same thing with the trauma. There is no right or wrong way to respond to the death of your spouse. People respond differently. And the state seems to be relying on this assumption that, well, Ms. Phillips should have behaved a certain way if this was innocent as opposed to not. The state doesn't know. One of the parts of the state's case that I want to address here is the inference that Ms. Phillips was drunk when she got into it with her husband. What evidence did you actually hear in the course of this case on that? Nobody asked Ms. Phillips how much she had to drink. Nobody asked her if she was drunk. You heard from Investigator Leinfelder, who was sitting across the kitchen table from her. He didn't see a need to run her through field sobriety tests. He didn't ask for a legal blood draw. And you saw that video at the Baymont Hotel front lobby. She looked drunk to you when she walked in there normally, presented her driver's license and her credit card, had a discussion with the front desk clerk about why the reservation didn't work, and then walk out without the clerk calling the police and saying, hey, some drunk lady is just driving away from here. Ladies and gentlemen, it's a red herring. It's something that the state is throwing out there because they have no explanation to support their version of events. And ultimately, what we're going to ask you to do is go back into that jury room and come back out with the truth. And you know what? I will be the first to acknowledge that that's a difficult thing. In many cases, it might very well be impossible. But the law gives you some guidance on how you sort through the evidence in a case where we don't have all the pieces to the puzzle and how you put it back together. And that comes in the form of the burden of proof. So what is it? Judge Levine told you that you can't convict Ms. Phillips of homicide unless the state's proven to you beyond a reasonable doubt each and every element of this offense. I'm willing to bet that most of you have heard that phrase probably 100 times in your life, proof beyond a reasonable doubt. But I'm also willing to bet that unless you've served on a jury before or spent time in the legal profession, you probably haven't spent much time thinking about what that actually means. So what do we know about it? We know that it's the highest level of certainty in the American legal system. That it's the type of certainty that you would require when you're making the most important decisions of your life. You know, ironically, perhaps for this case, it's the type of certainty that I've always thought of as you would have before you decide to get married, buy a home, have a child, undergo a life-threatening surgery. In other words, you've got to be really certain about something really serious. And if you don't have that level of certainty at a baseline level in Ms. Phillips' guilt, then you know that you're not at proof beyond a reasonable doubt. And I found that it helps to define what proof beyond a reasonable doubt is by comparing it to what we know it's not. We know that it's more than a simple accusation. It's enough to get somebody in the defendant's chair. We know that it's more than something probably happened, because that's the definition of probable cause, and in the criminal justice system, that's a pretty low burden. We know that it's more than the civil burden, where you're looking at both sides of the story and deciding which one is slightly more convincing. We know that it's more than the intermediate standard, what you'd use to commit somebody to a mental institution against their will, where you're looking at both sides of the evidence and one has to be substantially more convincing than the other. Proof beyond a reasonable doubt is unique in the sense that it's the only standard measured against itself. Because as Judge Levine told you, there's a second part to that. If you can reconcile the facts of this case upon any reasonable hypothesis consistent with Ms. Phillips being innocent, then you must do so and find her not guilty. There could be 100 different explanations for what happened here. But if even one of those explanations, ladies and gentlemen, is plausibly consistent with Mark Phillips' conduct and not Lori's created the risk, then your decision is very easy. If one of those explanations is plausibly consistent with Lori was reasonable to flee Mark under those circumstances, then your decision's just been made very easy. And if one of those explanations is plausibly consistent with Lori wasn't actively, personally aware that she had created a substantial risk of death or great bodily harm to her husband at the time that she fled, then your decision is very easy. Because those are the outcomes that you have to adopt and find her not guilty. Think about it like a deck of cards. Used this example before, but we can pull a deck of cards out, and I could throw one down. There's an accusation. It's enough to put somebody in the defendant's seat. Might take a third of the deck, pull it out, and say, that's enough to say something probably happened. Probable cause. We want to do a civil case where we're deciding whether or not Ms. Phillips was wrongfully terminated from employment, for instance. I take out both sides, measure them equally, slap one more card on, so we have 27 to 25. That's preponderance of the evidence. And the clear and convincing standard might involve taking 48, 50 cards, and leaving a couple other there so that one side is substantially more convincing than the other. For proof beyond a reasonable doubt, all of the cards have got to be on the deck. So what do the cards tell us in this case? I've described this already as like a puzzle with half the pieces missing. I wish that I had more information in this case as well. We know for a fact that whatever happened very quickly. We can tell that from the presence of the sunglasses on the driveway. We can tell that from the fact that Lori had to drive off when the passenger side door was still wide open. Everyone seems to agree that this wouldn't have been a prolonged incident. It's something that happened in the instant, in the moment. We can also tell from the evidence that Mr. Phillips was not upright when he was injured. How do I know that? Well, we know that from Dr. Reichert's testimony first and foremost, that he doesn't have the avulsion pocket injuries or the bumper type injuries that he would typically see in an upright pedestrian. Meaning that we can rule out a scenario where Ms. Phillips sees her husband in front of her, sees red, and then guns the engine and runs him down. That didn't happen. We can tell that from the autopsy findings. We can also tell that from the condition of the truck at the time that it was recovered. It was pristine. It was spotless. Don't tell me for 1 second, ladies and gentlemen, that Ms. Phillips can plow into Mr. Phillips with enough force to kill him with the side view mirror and it's not going to leave a single scratch. It's not going to leave any damage. Nothing on the grill. Nothing on the paint. Nothing to indicate that this vehicle had been involved in an accident. At some point, Mr. Phillips went from upright to down. And the state's own pathologist agreed with several possibilities entirely consistent with Ms. Phillips being innocent. He agreed that while this could be crushing, yes, it could be traumatic injury. He agreed that Mr. Phillips may have been caught and drug. We saw a picture of that belt that appeared to be clearly damaged, consistent with being caught on something. in that position where he was eventually found. You saw and heard evidence about the aftermarket steps that were on the driver's side, well, both sides of the truck actually, that stuck right out. And think about this from a practical standpoint, ladies and gentlemen. Mr. Phillips is running around to the side of the truck. He's about to reach that driver's side of the door, and then Ms. Phillips hits the gas. That's exactly the type of tripping injury that could cause him to fall over and get those left-sided head injuries that Dr. Reichert testified about. Left-sided exterior, left-sided subdural, he said hemorrhage instead of hematoma. And what else did Dr. Reichert say? Said that Mr. Phillips had bruises on his legs, consistent with that tripping hazard, ladies and gentlemen. He agreed that he can't rule out that Mr. Phillips was running after and jumped, or tried to jump on, or tried to hold on. He agreed that he couldn't rule out that Mr. Phillips fell over in the process of running over to the side of the truck. The point is, the state's own forensic pathologist testified that he can't rule out the innocent explanations for what happened on that evening. And that's a really big deal. So let's talk about the assault film. You saw the photographs. I know what I think I saw. Certainly use your own judgment on those. But in Wisconsin, all of us who drive our cars around know that unless you're washing your car regularly, you've got that kind of scummy salt film that builds up on the side of your car. And what we have on the side of the driver's side of the truck, towards the back, we've got something that appears to be clearly wiped away with a couple, at least, finger-sized marks coming downwards on the body of the truck. Now, if this is consistent with where Mr. Phillips was when he tripped, or when he started to fall, or when he tried to hang on, this is consistent with Ms. Phillips' side of the story. This is consistent with Ms. Phillips telling the truth and Ms. Phillips being innocent in this matter. I acknowledge that could be anything else too, but I bring it up to show that this is a piece of evidence that was right in front of the state the entire time, and they just skipped over it. They refused to acknowledge it. We don't have that luxury. And I want to talk a little bit about the fiber on the drive shaft. So let's assume that we don't have all of these issues with the fact that the truck had been driven outside of protocol and we have no idea what kind of contamination did or did not occur at that point. Let's ignore the fact that this cotton fiber could be from Mr. Phillips's jeans or from any other source of cotton anywhere in the world, and that Ms. Hank had no idea when it was deposited and by what method. But let's assume that it was from Mr. Phillips. The fact that it's there isn't important. It's where the fiber was that's important. It's at the very back end of the drive shaft weight, consistent with whatever happening outside of Ms. Phillips' field of vision. And if the state can't disprove an innocent version of events, then it can't prove its case at all. The state can't disprove these cases. They cannot show you that what Ms. Phillips told you happened in the course of this night didn't happen. And you know what? Do I know exactly what happened? No. But the difference here is that it's not my obligation to prove anything to you. It's the state's version, or it's the state's obligation to prove to you beyond a reasonable doubt that she's not right. And one of the more frustrating things about this, ladies and gentlemen, was this ability to corroborate, discredit, or confirm the version of events by the data that was available to them readily. We heard the testimony on why the Sheriff's Department didn't pursue this data, but ladies and gentlemen, that's nonsense. You saw the filings, you saw the emails. They said, we recommend that you download it. Worst case scenario, Trooper Marquardt loses an hour of his time and they don't get any data out of that. But even in the case of the telematics, they expected that data to exist for months. The type of data that could either credit, confirm, or discredit exactly what happened here. Ladies and gentlemen, had they gone through that step, had they done their job and collected that data, there's a pretty good chance that none of us would even be sitting here right now. Because that data, in particular the front-facing hazard detection, would have told us exactly how that injury occurred. And what the state seems to be suggesting in this case is that you convict on bad feelings alone. That it starts with this assumption of guilt, that Ms. Phillips must have been angry and not scared, that Ms. Phillips must have had no good reason to behave in the way that she did. And they're asking you to assume the worst and fill in the blanks. And effectively what the state's asking you to do is vengeance. You know what? Vengeance is easy. basic human response that all of us experience. Eye for an eye. That we see somebody that we love, that we've lost, and we want there to be a bad guy. We want there to be somebody to blame. Because it's so much easier to strike out in anger than focus on our own feelings of loss and grief after losing a loved one like this. But you all promised you wouldn't do vengeance. You promised you'd do justice instead. And justice is more difficult than vengeance. Justice requires you to look at the facts instead of the feelings. Justice requires you to make difficult decisions. And I'll be the first to tell you, justice doesn't always feel good. Nevertheless, that's what each and every one of you swore that you would do. And I told you from the beginning of this case that it's okay to have empathy for Mark. It's okay to have empathy for his family. Mark isn't somebody who was 100% pure evil. Human beings are much more complicated than that. We're not some one-dimensional cartoon characters that can either be classified as hero or villain. And I have no doubt that in his life, Mark was a good dad, a loving brother, a son, a good friend, the life of the party. But you know what else I don't doubt? That when Mark was drunk, he was an abuser. And that was the Mark Phillips that confronted Lori on the last night of his life. Which leads us to the why. Assuming that you conclude the state has met the other elements, you have to ask, was this reasonable under the circumstances or not? And we're not viewing this in a bubble. We're viewing this from Lori's perspective at the time that she acted. And in my mind, the very definition of reasonable doubt existed the instant that the state's witnesses acknowledged that they would never tell a victim in Ms. Phillips' position to simply stay there and find out what abuse is coming next. Now, the state didn't want to answer questions about what 911 dispatchers might say, but use your common sense, ladies and gentlemen. You really think that any law enforcement officer or dispatcher would tell somebody calling saying, help, my husband's coming to hurt me, help, that they would say, you can't take off because that might put him in danger and we don't want that, so you should probably just nonsense. Ladies and gentlemen, the state used the example of a green light turning yellow and turning to red as an example of assessment of risk. And, you know, if this were an ordinary traffic case about whether or not somebody caused an accident at a four-way intersection, yep, that'd be a fair comparison. But in this case, if the light turns red when you haven't properly assessed the risk, it's not going to jump out to your side of the car and strangle you. Those were the consequences in Ms. Phillips' case. That's what she had to decide in a period of just seconds, whether or not she would stay or go. And in this case, I think that the fact that there's a history of domestic abuse was both acknowledged by the state and corroborated by the evidence. This is something that happened in private. It happened in public. You heard from Mr. Gierock. He had the audacity, and I'm not going to say that word myself, to scream that at her and pull her off of a bar stool. You heard from Ms. Phillips about that terrifying moment when Mark broke into her apartment and strangled her in the middle of the night. You heard from the others at the dive bar about how upset and how out of control Mark was, and you saw that footage for yourself, flailing his arms, pounding his hands, getting right into Ms. Phillips' face and screaming at her. He was out of control. And on that night, Lori had never seen him in that state before. She'd never been more scared of him. On that night, Mr. Phillips strangled her. We know this because of her contemporaneous text messages to Hannah. We know this because investigator Lionfelder testified 3+ years ago about the fact that he did observe an injury around her neck area. We know this because of the photographs that Lori submitted of her injuries throughout the course of this case. And we know this based in the context of Mark's behavior throughout that entire evening. Something that was observed by Ms. Klinsky, by Mr. Stevens, by Ms. Phillips, by the video surveillance system itself. And we can't ignore those photos of Lori's injuries the next day. And this is just one of the things that's just mind-blowing to me, that there was a description of a domestic incident leading up to this, and there was no effort to say, let's document your injuries. Let's take some pictures of this. Let's take you in to go to a forensic nurse to make sure that everything is documented and taken care of. That was left to Ms. Phillips' friends, who were shocked to see all of the bruises on her that each and every one of you saw after the fact. Bruises that corroborate her injuries, that corroborate the pain that she described in her breast. Bruises that corroborate what Lori talked about when she was forced down into that car. And where was Lori when Mark was in this condition? At the end of the evening, he's inside of a truck. Slammed up against the truck, dragged in there hard enough to leave a bruise on her bicep, punching the window. And ladies and gentlemen, I disagree with the state's contention that punching a window will necessarily leave injuries that'll be noted in an autopsy, but that's neither here nor there. And she's locked in this truck, and where is he bringing her? He's bringing her back to rural Holman. Nobody's going to hear her scream for help. Nobody's there to protect her. If she called 911, ladies and gentlemen, how likely is it that she's even going to get a ringtone before Mark's already at her door? Lori is on her own at that point, and she's with Mark, who's visibly drunk. How do we know he's drunk? His blood alcohol concentration was a 0.149. Now, we don't know exactly where he was at the time of his death, but that was the blood content at the time of autopsy. That's legally drunk. That's well over the legal limit to be driving. And in this point in time, when her husband is drunk, enraged, taking her to this isolated location, he charges at her in a matter of seconds and forces her into that decision. I want you to think about that, ladies and gentlemen. How would you like to make the most important decision of your life and be given only 3 or 4 seconds to do it? For the sake of comparison, most NFL quarterbacks get more time in the pocket than Mark Phillips gave Lori that evening. And you know what? She better be right when she decides. Because if she's wrong the one way, well, now she's on trial for homicide. But if she's wrong the other way, ladies and gentlemen, we might still be here. Only the title of this action wouldn't be the state of Wisconsin versus Lori Phillips. It'd be the state of Wisconsin versus Mark. And when Lori reacted, that was the very definition of instinct. Fight or flight. This wasn't a conscious thought process. This was a reaction. This is something that's ingrained in your very DNA as a basis for our survival. And the state's trying to fault her for that. It's not unreasonable, ladies and gentlemen, to follow those basic human instincts. It's not unreasonable, ladies and gentlemen, to get yourself to safety. It's not unreasonable to tell anyone in that position that they need to look out for themselves first, rather than taking care to make sure that they're not doing harm to their abuser. And if you believe that one reasonable option under those circumstances was for Lori to flee her husband, then your decision's just been made very easy. Because that's the very definition of reasonable doubt in this case. And the only proper verdict is not guilty. That brings us to the final prong of the state's burden here, and that's whether or not Ms. Phillips was personally aware of her conduct creating a substantial and unreasonable risk of Mark dying. And I think it's important to reiterate that this is not a burden of what should she have known. It's a burden of what she actually knew. And all of us agreed at the beginning of this case that when you're in an accident, you're not thinking about what the gradient of the tire was on the back if you're going over a snowbank, or how fast the vehicle is spinning or yawing in one direction. You're thinking about how hard your heart is pounding out of your chest. You're thinking about how you're having a near-death experience. And in a case like this, the evidence shows overwhelmingly that Lori had no idea that Mark might have been injured when she fled from him. We see this in her text messages back and forth with Ms. Klinsky. We see this in her contemporaneous remark about that faulty text message coming in about happy hour, where Lori's like, Mark just texted some friends about going out for drinks, typical, or whatever the text message said. We see this in Lori's text messages to Mark, telling him that marriage may be over, that she's not going to Bismarck with him. She's not sending these text messages, ladies and gentlemen, if she has any reason to believe that her husband is on the side of the driveway dying. The same thing can be said of what she said to Ms. Klinsky. And to me, this is one of the linchpins that tells us exactly what Lori was thinking. She was still scared of him. She was still scared at the prospect of abuse, because when they offered her a safe place to stay in Winona, she said no. Mark would freak if he found out that I went to Winona. You all heard from Lori. Mark didn't let her go there alone. She had exes there. And Lori's indication in response to that text message tells you all you need to know about whether or not she believed that Mark had been injured at that point. The same can be said for her search for a hotel and a place to stay. If Lori's intention here was to run him off the road and leave him there to die and then come back and stage a scene after the fact, then why on earth is she looking for a hotel? Why on earth is she trying to find someplace else to stay? If that were truly her intent, why not go back there and clean up the scene? The fact that she's looking for a hotel tells us that Lori's telling the truth. She didn't feel safe going back. She didn't want to go back because she had every reason to believe that her husband was drunk and furious and still there. And in that context, her Google searches also tell us a great deal about what happened. Aside from looking for a hotel, what is Lori Googling? Physical abuse. And physical abuse, quit or quote, however you want to remember that. She's Googling that, ladies and gentlemen, because she was trying to figure out exactly what happened to her. She wanted Mark to have some sense of exactly what happened to her. And that's exactly why she sent him that text with the quote from the domestic violence resource, that she wanted him to reflect on it. She figured he'd reflect on it. Think, man, I could lose my marriage over this. She wasn't sending that to somebody that she believed to be dying or dead. And the camera views of Lori turning on or arming and disarming the cameras is also consistent with that state of mind. You heard Lori's explanation. You heard she wanted to see if Mark came after her in the Subaru or if he went out to another bar. You heard that, yes, she acknowledged that she wanted to see if Mark followed through on that threat or comment to go bring some other women back to the house, which is why she's looking at all the camera feeds, including the one over the hot tub. And when she comes back, she turns it off because she doesn't want it to trigger her passed out husband, who might realize that Lori had arrived and come back for round two. The fact that she turned it back on is also consistent with the years of abuse that Lori suffered. That was something Mark expected as well. And she turns it back on at, I believe, just shy of 5 a.m. in the morning when she was on and off sleeping upstairs. That's consistent with Lori's story. That's not nefarious, ladies and gentlemen. And I want to talk a little bit about the snowbank here. I told you that a picture is worth 1,000 words at the beginning of this trial. And hopefully the photos that you've seen have proven my point. But if there's anything that I want you to pay attention to with this question of whether or not Lori would have known, should have known, could have known that Mark was out there when she returned in the middle of the night at 2 a.m. in the pitch dark, it's Sergeant Valencia's squad car video. This was before a sheet was ever placed over Mark, and we showed it to you frame by frame by frame. Mark Phillips was invisible in any of them. This was a circumstance where he was right there in the snowbank, under circumstances where unless you look right over 90 degrees in a direction that you're not traveling, you're going to miss him. Particularly when you hear that Ms. Phillips came up by way of West Salem, it wouldn't have been coming from the west like Sergeant Valencia, where he could see Mr. Phillips' body in the twilight. She was coming from the other direction where he wouldn't have been visible, coming up the driveway under circumstances where he was perfectly concealed in that snowbank. And we know for a fact that Mark had likely ended up in that snowbank initially after the accident, and that he had been there for almost the entire time because his body heat had melted the snowbank all the way down to the grass level, and then as he cooled, he actually refroze in that position. I think the evidence is fairly clear that Mark had been in that position from the original point. And it's entirely plausible under the circumstances here, in a truck that she's only driven a few times before, much higher vehicle, that she wouldn't look in a direction that the direction of travel would be as she happened to pull in to that portico between the house and the man cave. And in order for the state's theory to make sense, that this was an act of jealousy and Ms. Phillips knew when she was combing the cameras, hoping that something bad hadn't happened, all of this prior evidence would have to be an act. Her text messages, her responses to Hannah, physical evidence in the home, all of that would have to be a ruse concocted by somebody who, despite being accused of committing a crime of passion, would have to have an awfully good understanding of Wisconsin criminal recklessness law in order to come up with her story and come up with her version of events and fake all of these text messages and comments throughout the night. Ladies and gentlemen, the simplest explanation is usually the true one. The true explanation in this case, is that Lori Phillips didn't know that Mark was injured. And in order to prove otherwise, the state would also have to prove to you that her reactions on those video surveillance systems from the home were also faked. You all saw that. If that was an act, then let's get this woman a statue. Because, ladies and gentlemen, that was the reaction of somebody who saw her husband for the first time dead on the side of the driveway. She didn't fake that. She didn't fake her panic 911 call. And she certainly didn't fake it with the 3 officers who interacted with Ms. Phillips that day. Sergeant Valencia, Investigator Lionfelder, and Deputy Stollinger, all of whom described her as extraordinarily upset. So upset she couldn't stop shaking, distraught. The reason that Lori was so distraught in those videos, in that 911 call, in front of the officers, is because she was telling the truth. She had just experienced the worst moment of her life, finding this man that she had a complicated relationship, but a man that she loved nevertheless, dead on the side of the driveway. And if that's what the evidence suggests, then ladies and gentlemen, the state can't possibly prove that she had the required knowledge at the time that she left the driveway. Knowledge that she was risking Mr. Phillips' life. So where does that leave us? I'm going to go back to the deck of cards, ladies and gentlemen. And remember, I told you that proof beyond a reasonable doubt, you're not comparing one side of the story to the other. You're comparing it to yourself. And in fact, you're comparing it to see if all of the cards are back in the deck. So is there reasonable doubt in this case? Absolutely. There's a corroborated history of physical abuse. There's Mark's behavior in the bar, captured by witnesses and videos. There's his blood alcohol concentration of 149. Dr. Reichard's agreement that this accident could have happened in a way consistent with Ms. Phillips's innocence. Mark's perfect concealment behind that snowbank. Lori's video reaction in a 911 call. The corroboration of all of Lori's movements after the fact and her cooperation with law enforcement in providing her phone and camera login information. And that fight or flight instinct that each and every one of us can understand. And you know what? I am a true believer in our system of justice here in the United States. And that I believe that a group of 12 people selected randomly out of the voting rolls, that's how we found you're all good citizens, can come to a better conclusion than any one of us could individually. And I respect the fact that in the course of your deliberations, the 12 of you might be able to take some of these cards and put them back up on the deck. But before you reach the result that the state is asking for, they've all got to be there. And they're a long ways away from that. So the way that this works is that the state gives their closing argument, and now I'm giving my summation, and since the state does have that highest burden of proof, they get the last word. When I say thank you and sit down, that'll be the last that you hear from me during this trial. I'm confident that whatever Mr. Burdick says in rebuttal, you'll treat with the same degree of careful analysis as you've treated the rest of the evidence in this matter. So if there's any one thought or theme that I want to leave you with as you go into your deliberations, I want to bring you back to that final confrontation outside of the dive bar. Mark has Lori slammed up against the truck, and you heard her testify that she raised her voice. Stop, Mark. Stop. You've done enough tonight. Hoping that the people in the parking lot will come to her rescue. Hoping that somebody would put a stop to it. Nobody did. Nobody came to her rescue at the home. Ladies and gentlemen, the 12 of you who deliberate have the power to come to her rescue 12 years after the fact. You have the power to say that what happened to Mark was awful. It was tragic, but it wasn't a homicide. Lori Phillips is not a murderer. The only proper verdict in this case is not guilty. Thank you for your time, thank you for your attention, and thank you for your service in this case.
Thank you, Mr. Zacher. We have rebuttal. Usually it doesn't take as long. Is everybody okay? All right. All right, go ahead.
Ladies and gentlemen of the jury, I want to start off with some of Attorney Zacher's points, and I'm going to kind of work through, and I get an opportunity to address his points with the last word.
Attorney Zacher starts by saying that there's overwhelming evidence, or I guess not starts, but he says there's overwhelming evidence that Ms. Phillips didn't know that she caused the injury to Mr. Phillips. Ms. Phillips would have you believe that she was so scared, she was in such the heat of the moment, that she was unable to feel or experience anything. If you've hit a small animal, if you've gone over a speed bump, if you've hit a curb, if you've hit a pothole, if you've done any amount of driving, you know what happens when you go over that. You know how your car feels. You know how you experience it in the cabin. You know that moment when you go over the speed bump and the whole car feels like it moves and jars and shakes. What about a 220-pound man? What about a 220-pound man the size of Mark Phillips? You can't say she didn't know. I showed picture, the exhibit about the trash can's behind the house. She didn't think she hit the trash can. Snowbank, pulled to the side, it tapers off at the end, goes over the little bit of snow there on the end, didn't think she hit a snowbank. That she experienced nothing, felt nothing, heard nothing during that incident is not the truth. That is not accurate. You use your common affairs and understanding of life, you can make that conclusion. There is no way she didn't know. Overwhelming evidence, I would argue, is not true. Mr. Zacher also says that oftentimes the simplest explanation is the best explanation, and here it is. People just don't find themselves under trucks. Gene fibers just don't find themselves on drive shafts. The tears on Mr. Phillips' jeans, consistent with everything we've heard and that thread that was found. Attorney Zacher pulls out a deck of cards and tells you to kind of work it down and what we could do and the different types of standards of proof. I would at least note that Mr. Zacher is using a process of elimination approach to get to that final card. The same thing that I argued to you in my initial closing argument about the cause, about what we can rule out, about what we know. Same type of reasoning. But it is important to also remember that while I have to prove to you beyond a reasonable doubt, I do not have to prove to you all doubt. The standard that doesn't exist in terms of in the law, that every possible speculative possibility known to being theoretically possible, I don't have to rule that out. That is not my burden of proof. It is beyond a reasonable doubt, consistent with the evidence. Going through, Mr. Zacher wants me to pick a mechanism for how Mr. Phillips perished that night. And ladies and gentlemen of the jury, it's substantial factor. I don't have, in terms of the causal mechanism, which tire, back tire, front tire, whether Mr. Phillips, what happened in the undercarriage once he has been gone over in the truck by Ms. Phillips, that's not substantial factor. That's a causal mechanism. That's somebody were to say, a battery case. I don't have to tell you which fist the person used. It's enough that they cause harm. Criminal damage to property, substantial factor of cause. I don't have to tell you which side of the brick hit the window and it broke it. I just have to tell you that was the substantial factor that caused that criminal damage to property. Emotional distress, causing emotional distress, for example, I don't have to tell you or prove as part of that substantial factor cause which neuron in the brain caused which emotion to misfire. That is not my burden. The truck here, the evidence you have, a substantial factor that when that truck went over Mr. Phillips' body, it compressed him in the pavement and it crushed him. And it crushed him on the side. Consistent with the evidence that we saw, we know that Mr. Phillips was in front of that truck. We know that Mr. Phillips is looking at the driver's side window of that truck. We know that the truck crushed the left side of his body. If you're facing the way I'm facing you, and ladies and gentlemen, I guess I'll turn my back and look ahead. My left, my right, that's looking at the garage. And I'm on the driver's side. And that vehicle passes over me. Which side is it going to crush? It's going to crush my left side. The momentum is going to pull me back, and I'm going to end up down the driveway in that situation. Exactly consistent with where you saw that body, the positioning and everything about it.
ladies and gentlemen of the jury, in terms of this idea of Ms. Phillips not corroborating or, Ms. Phillips covering it up, that is what I'm arguing, that she did. That she knew, that she went to the subdivision, not because she's an expert on criminal recklessness, because that she was afraid. She reasonably believed, knew, was aware that she just hit her husband, went over him, and she went to that subdivision. She's not awaiting her rescue. She's not looking for any help. She's afraid she's going to get arrested for an OWI, operating while intoxicated. And this is not that case. Did I prove that Ms. Phillips is drunk? Of course I didn't. But that's her words. And then later in the text communication from Ms. Klinsky, what does she tell her? Don't drive. If they see you in the parking lot, they'll arrest you. That's the person who was with her almost all night. Those people know how much Ms. Phillips drank. Those are the two instances we do have of how much Ms. Phillips had to drink. Did she appear intoxicated on the videos? Can't say that she did. But did Mr. Phillips? You saw him move his hands. You didn't see him stumbling. You didn't see him fall down drunk. You didn't see him look particularly drunk, but you know what his BAC was. Ms. Phillips wasn't covering up what happened after because she is an expert in criminal recklessness, but she did cover it up because she was afraid of getting in trouble, because she had been drinking, because she had just did what she did, and because she didn't want anyone to know about it. Mr. Zacher wants to bring up that Ms. Phillips, her field of vision. And I think that goes back to, let's look at the instruction. It is aware of a substantial risk, aware of a substantial and unreasonable risk. It is not see right in front of you. We have the mirrors. Can you pull up that? This is the side of the car. The car itself has everything in terms of what we're looking at. We can see that the foot rail doesn't go outside of the tires. We can see that the mirror does, in fact, extend a little bit out of the door. But that's part of the operation of the vehicle. That's a part of what you're aware of. That's a part of the actual vehicle itself, the part that is going to cause that substantial and unreasonable risk. That's what you're aware of. That includes what's around the vehicle. That includes what you know. That includes your rate of speed. That includes the mirrors. I mean, if you were to drive into let's say a parade or a parking lot or something like that with the mirrors out, and somebody gets clipped by that mirror and then goes under the car, well, I mean, he hit the mirrors. That's good enough. No. That is a part of the vehicle. That is a part of the risk that she is aware of when she took out of the driveway that night, and she did it the way she described. I will not belabor the point of whether those two small indicators are fingers or not next to the gas tank. But again, that goes to the mechanism. Once Mr. Phillips is under that truck, and once Ms. Phillips takes off, creates that risk, is aware of the risk, knows that we're exactly where he's at, knows what what's happening, knows that there's the driveway and the clearance. I mean, if he goes under in his last efforts to try to right himself, grabs that gas can and then drags while he's being hit by the truck or crushed by the truck is still a substantial factor. And Ms. Phillips drove the truck. That's still your substantial factor. He's under the truck. Let's talk about some of the text to Hannah and things like that. And Judge, how am I doing on time?
I'll give you another 5-10 minutes.
5-10 minutes. Then I will be brief. The text to Hannah, they show indicia of guilt. Here's why. Because the first text in that chain, the one that happened at the dive bar, is, shit just got real. I'm deleting this. And then you know from the Cellbrite data that she does, in fact, delete that text. Now, that's at the dive bar. That's in the bathroom at the dive bar. That's consistent with the time. But Ms. Phillips says that the reason she had to do that was because Mr. Phillips takes her phone, and he looks at it. And she's worried about what's going to happen next. In the days, et cetera, when he gets her phone. So she doesn't delete any of the other texts in the chain. She talks about domestic violence. She talks about, the being hit. She talks about everything like that. All of those things that would have made Mr. Phillips mad, that whole communication between her and Ms. Klinsky, they're not deleted. She didn't have to. Because she knows.
because she knows what just happened. She knows how things had happened, and now she's trying to create this record. She's getting in touch with Hannah. She's using details that are similar from the dive bar. It's out of context, out of text. While she's doing that, she indicated that she is pulling up her phone and live streaming it. Ms. Phillips' version of events is consistent with somebody who is trying to cover up what had happened. She's creating a record. She's making sure that everybody, and that anybody who has the opportunity to see this, that she has, I guess, for lack of a better term, an alibi. Also, she knows that she needs to create a significant enough time period that when she eventually makes her 911 call, she has to be sober. Otherwise, people will start asking questions, and that, based on her statements to Investigator Leinfelder, is what scares her, knowing what had happened. Yeah.
Okay, yep.
And Judge, this is my last call. So we're almost at the end of our presentation. I will go through this brief as I said I would. How do we know what Mrs. Phillips has experienced? This is her with Investigator Leinfelder. I didn't respond because I was so pissed off. She said that twice. Next slide, please. Ms. Phillips discussing her version of events. You put your hands on me, you just live and you let go. She's being provocative. I made a scene outside. She's mad. She's mad at Mr. Phillips. This is at the dive bar. Next slide, please. Ms. Phillips, I took the phone and I said, leave Stevens out of this. Quit calling Stevens. She's talking about Adam Stevens. She's mad. She's mad at the bar. Mark has embarrassed her. Mark has embarrassed her in front of her friends. Not his friends, her friends. And she made special note of her friends, their family, that being their first impression. Ms. Phillips is embarrassed. And she's mad. And Mr. Phillips is being a jerk. And he's being loud. And that is making her mad. Leave Stevens out of this. Quit calling Stevens. She's mad. Next slide, please. And now we have, this is her message to Hannah regarding, this is what's concerning Ms. Phillips at 12:07. Sleeping in truck, Mark sent a text to friends asking to go out drinking. I'm sure he'll hook up with yet another chick in our relationship. This is after she has told him she's done, completed, she's moved on, she's escaped. Next slide, please. This is her sending what I've referred to and asked about is a facetious or a sarcastic text. And that was some of the testimony to corroborate that. Next text. She's mad. This is right after this happened. He told me when he was taking his stuff, he was going to go to HG. So I assumed because I was going to use these 2 bar chips I had tonight. When she testified, she talked about that Mr. Phillips is in the car saying that he's going to hook up with other women. He's going to do this. He's going to do that. He's going to go out to the bar, and her texts corroborate that. And then she told us that she's checking the live feed because she's afraid that other women are going to come back to the house. She's jealous. She's mad. She is not happy. And then those HG tips, that is what happened in the front seat of that truck. That is what happened in that particular period. That's what she's talking about. That's what set it off. And that's when her jealousy causes her to take the F out of there. She's mad. Mr. Phillips is not physically abusing her at that point. She's mad. He's being rude, sure. They're arguing, sure. But that's what set her off. And then she takes out of that driveway, and this is the last slide. Why didn't Miss Phillips? The point of why would Miss Phillips come back to the scene at all? It's a fair question. This is from Deputy Valencia, or Sergeant Valencia's squad car. This is what we saw. This is one of the first things we saw today. Oh, thank you. Miss Phillips has to return home. She can't go to Winona. She can't get a hotel. She can't stay somewhere safe. She can't stay, get the neighbor for help.
she has to return, and she knew she had to return before she did because of this. This was 250 to 300 yards is what Sergeant Valencia said. This is what everybody that morning, she came in the other way. I can't represent, she came in the opposite way. She knows this is what everyone on Saturday morning is seeing. That's her window. That's the time. That's how much time she has to figure out what she's going to do about the situation that she caused. Right there. That's what everyone's seeing. And that's what's going through Ms. Phillips' head. And she knows that if she doesn't get home, she loses the opportunity to control the narrative. She loses the opportunity to tell her version of events, her side of the story, because of that. If she stays in a hotel, she stays in Winona, she goes somewhere else, she can't control that story because someone else would have found Mr. Phillips. So ladies and gentlemen of the jury, thank you for your time. Thank you for your consideration throughout this week. I ask that you find the defendant, Lori Phillips, guilty.
Ladies and gentlemen, the following two forms of the verdict will be submitted to you for your consideration concerning the charges against defendant Lori Phillips. I'll give you a second there. One reading, we, the jury, find the defendant Lori Phillips guilty of second-degree reckless homicide as charged in the information. And the other reading, we, the jury, find defendant Lori Phillips not guilty. It is for you to determine which one of the forms of the verdict submitted to you you will bring in as your verdict. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may be legally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you're deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, sign it and dated by the person you have selected to preside. After you reach a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. So at this point, we will swear the officers. Come on up, the bailiffs.
Do you swear that you will, to the best of your ability, keep all jurors sworn on this trial together in some private and convenient place until they have agreed on their verdict or are discharged by the court, and that you will not, before they have rendered their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon?
So today we now we'll select the two alternates, and what I usually do is I just take the date and have those as two numbers, and just so you know, you are randomly given a number, and then it's randomly put on a list, and then we give two random numbers. The two numbers today is the November 10th, so 11-10 are the two numbers. Go ahead.
Gavin Martin and Todd Newman.
Mr. Martin and Mr. Newman? Oh, that's very odd. You're both at the end. So you are the alternates. Thank you so much for your jury duty through this. If you'd like me to answer some questions, yeah, you can go ahead and have a seat. I will be out in a bit. We have to take care of a few things and get the jury out. What I want to do is first have you two go out, grab your things. If you'd like to, I'll meet you in my chambers. Or if you'd like to go, you're welcome to go. Thank you so much for your jury duty over the whole week. I hope it was good. So we'll have you two go on out. And Terry, why don't you just take those two? Yeah. Thank you. I'm going to stand up. And the remaining, once they're out, we'll have you go into the jury room and start deliberating. See you there. You can start heading out. Go ahead. Everybody may be seated. Has the jury reached a verdict? If you could give the verdict to Terry, and she'll hand it over to you.
State of Wisconsin versus Lori Phillips, La Crosse County case number 20 CF 364. Verdict: we, the jury, find the defendant, Lori Phillips, not guilty. Signed by the juror foreperson, dated this 10th day of November 2023.
Members of the jury, as to count one, is that your verdict? I just need you to say yes in unison if that's correct.
Yes.
All right. Would either party like me to poll the jury?
No.
No, Your Honor.
With that, members of the jury, you are now completed your service. You've been having 5 hard days here. Sorry the food came late, but this has been a difficult trial. I understand that. I will talk to you once we're done, and we'll talk about how we go from here. I do need to inform you, or I can inform you, you do not have to answer questions about the case with anyone other than the court. There is no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. You are, and I do give a little bit more advice, which is if you are willing to talk to somebody like the attorneys, sometimes they want to know what happened. You're always welcome to talk about your experience. I'd ask you not to talk about the other jurors and let them say what they would like. Otherwise, I do thank you so much for this whole week. It's been a very difficult week, very difficult to end here, and I appreciate all your attention and all your hard work. I will be right up there. Thank you again. All right. With the finding of the verdict, the court will find that Ms. Phillips is acquitted at this point of the count. You're released from, I don't even believe there was a bond because of the appeal process, but the case is now concluded. Is there anything further from the state at all?
No.
Anything further from defense?
No, Your Honor, thank you.
One last thing is, I know this is difficult for both families here. I'd ask just for, we have court officers here, if the family, and I know there's a large part of the family for Mr. Phillips here, why don't we have you go out first, and then we'll have Ms. Phillips, Gamoki, our family, go out next. I never know what to say to everybody about something like this. This is very difficult, and now it's a time to heal, to try to figure out how we heal. I hope, I know it's been a difficult week, and actually I appreciate that you're all here, because I think this is important for the criminal justice system, for everybody to be here. So, take care, everybody, be safe, all right? Thank you.